Thank you. Good morning, my lady and my lords. Yes.
Mr. Mbogo, before you start, we have looked at today's outline, and we don't believe that we need to spend the whole day in court based on this outline, right? So we're starting now at 9:30. In terms of the outline, you would have had an hour, but we are comfortable with you going up to tea time. Up to 11, right? So that gives you 30 more minutes than planned. And then yesterday we heard from Mr. Matibedi, so we don't need to hear you again today. We heard from you yesterday. We don't need to hear you again today. Yes. So the time provided for him, we don't, yes, exactly. We don't need to use it on him, which moves the amicus up, right? So we'll hear the amicus from 11. The amicus is allocated 30 minutes, right? And then we hear the applicant. The applicant replies for an hour, according to what's planned.
Yes, and we'll use that for both the amicus and the main reply.
So that takes us to 12:30. Right. And then I see this provision for Mr. Mpofu to rely to the points in limine. But strictly speaking, Mr. Mpofu, you don't have that right.
Well,
Strictly speaking, you don't have that right. So I think we'll just leave it open. We're open to being in court until 1, in the event that we need to hear you. So maybe you shouldn't preempt whether you should reply or not. If Mr. Manaiche raises any new issues in relation to the points in limine that you've not dealt with, then that's when you will use that time. Yes. So the projection is that by 1:30 we will conclude today's proceedings. Thank you.
thank you very much, my lady. I just want to then, because we had our own discussions as to how we were going to divide up the time, but I think that's fine. We'll work according to this arrangement. Anyway, what I seek to do, what happened yesterday is, for a good reason, we deviated to the merits. And that's not necessarily a bad thing, because in any event, it means we won't have to cover some of that ground. But what I'd like to do is to structure the argument back into the plan, as it were. And I've had a look as to where we deviated to the merits. As I say, I'm not complaining about it, because it's ground that we're going to cover anyway. But the point at which we did deviate was at the point at which your ladyship asked, or rather raised with me correctly, the issue as to whether in Mukhesi, because of the facts of that case or whatever was raised, it was not different from here. And that then obviously had to take us back into what is the nature of the matter. And then we ended up delving with the merits. So we'll come back to that. What I want to do now is to go back to wrap up the point that I was making when that happened, which was that on the prematurity stroke jurisdiction point, not only were the binding authorities of Tint and Moyo followed in Netco and other provincial cases, but most recently in Mukhesi. After that, I'm then going to deal with the only outstanding issue on the points in limine, which is locus standi. Then we'll come back to the merits, as I say, without repeating what we've already covered. So that's the plan that I wish to follow. Now, maybe I'll start with what I had put as a summary so that the points can flow. One, we've said that there is binding authority for the proposition that in general preliminary litigation should not be allowed, should not be countenanced, should not be entertained. And all those phrases come from the cases. Now, when you say something should not be entertained, that's the quintessential definition of jurisdiction. Because as it was said in the Makanya case by Nugent J.A. very eloquently, jurisdiction has got nothing to do with whether you're going to win or you're going to lose. You don't have a right to be heard, whether you have a good case or a bad case. So it's apart from the merits. And hence, in NETCO, for example, the power, the court said it doesn't have the power to deal with title to prosecute, which is a synonym in legal terms for jurisdiction. And hence, in the other matter, I think it's more, it said it should not be entertained again. So entertained for better or for worse, it should just not be entertained. So that's the thrust of the submissions made by my learned junior, Mr. Mwela, and myself. If you want to put it cryptically, he was dealing with the matter from the point of view of where the matter should be heard, as between the civil court and the criminal court. And I'm dealing with it in respect of to when. That's the prematurity point. In other words, even if we were in the right court, when. So that's really the nuanced difference between my submissions and his. But it covers the same ground because it all comes down to the issue that title to prosecute ought to be heard under Section 106, 1H in the criminal court, or before the magistrate or whatever, whoever is hearing the actual criminal matter. So that's the first point. The second point is the debate that I then had with Justice Park, because he was again correctly pointing out that, like most rules in law, there are very few rules in law that are just, they say it's this or and no, without allowing for any exceptions. That the one thing we all learn in law school for how many years is not what the rules are, but mostly what are the exceptions and what have you. So that was correct. So, and I was explaining it to my juniors last week like this, to say, to put it simplistically, the law is that when the robot is red, you don't cross. That's the law. But of course, there are exceptional circumstances if you are driving an ambulance or whatever. But it doesn't deviate from the fact that this is the general principle. And that then takes us to the point which I want to emphasize, namely that the ambulance driver or the person who wants to deviate from the law is the one who must tell you that you must deviate. And our respectful submission is that in this case, not only have exceptional circumstances not been pleaded, or rather not only have they not been established, but they have not even been pleaded. So it's impossible to establish them when they have not been pleaded. And that's why the court kept on asking us as to, so what do you think would be exceptional circumstances and so on. So there's no reason for any deviation from the binding cases. What is worse, and I remember raising this point, but I think when a question came and then I moved to something else. But I do want to put a stamp on this. One of the disadvantages, let's call it that, and that's why I was saying it's illogical why any right-thinking person would resort to preliminary litigation when they have an avenue that could even result in their acquittal. But the other, to emphasize that point, and that point goes to why are we here? We're here for what Justice Wallace calls the propensity of well-resourced, prominent people to engage in delaying tactics by raising constitutional points, which is otherwise known as preliminary litigation. Sorry. Okay, sorry. And so that's very important, because there's no other logical reason, to be honest, why anyone would do such a thing. There's no human being who would say, instead of have a route, I could go to Pretoria this way, and there's the straight route, but no, I think I'm just going to start in Bloemfontein and then go to Durban, and then it's unnatural. But also, for another reason, because to choose a civil court is basically to shackle yourself as an applicant, because you're going to subject yourself to the Plascon-Evans rule, where the version of the respondent is going to prevail. For that reason, again, there's no human being who would do such a thing. Because let's take the so-called Nazareth theory. The court has no option. The respondent has given a very detailed account as to why the summons was issued when it was issued. Chapter and verse, some of it I covered yesterday, I'm not going to retraverse. And he says, this had absolutely nothing to do with the fact that there was a conference starting, except for the fact that I was also going to that conference. And he details it. Now, in terms of the Plascon-Evans rule, a civil court has no option but to accept that version, except if it can be shown that it is far-fetched and it's that cannot happen here, because there's not even a bare denial of those averments. You'll remember that that explanation is given in the Rule 65E answering affidavit, which is not even opposed. So even if there was no Plascon-Evans, this court has no choice in the matter, because it's sitting as a motion court. But it can't say no, we think it was Nazareth. It's impossible, because as a civil court, but a criminal court which could have had opportunity to interrogate the issues might have found that yes, there's a Nazareth here. So who as the younger generation say, who does that? Who wants to take the long winded route that goes up and down into the water and whatever, when you can just get yourself out of trouble as soon as possible? So the only reason can only be to delay the inevitable. Right. Now, I want to round this off then by saying this. That and that takes us to where, as I say, where we affirmed yesterday. The approach in Tint was correctly followed in Tint and Moyo, was correctly followed in Netco, that Mr. Muela dealt with that yesterday. I'm not going to go, it was in the Southeastern Cape Local Division. It was followed in S versus Zuma in the by Judge Kuhn recently in the Peter Marisbeck judgment. It's in the papers. I think it's paragraph. Okay. Well, anyway, he quotes the Tint one.
108. It's paragraph 8 of our heads.
108. Oh yes, it's referred to in our heads. Paragraph 108. I know there's a paragraph 103 and there's a paragraph 108 which deal with this issue. Here's the catch. In fact, Justice Kuhn went further because he said, if it's a pure 106, you may raise it obviously at the normal time when you are doing the plea. But if it's coupled with a Section 35 complaint of challenging fair trial rights, you should even not do it even at Section 106 stage. You must do it at the end of the trial. That's what he said. He said once the court has had the criminal court, obviously. Once the criminal court has had a full sense of the issues, then at the end of the trial, it will be able to assess the Section 35(3) complaint. Now, let me just own up to the fact that I think that second proposition goes too far, because you should be able to complain about your 35(3) rights at any stage, as far as I'm concerned. But that judgment, we tried to appeal that judgment on that very point, and it was upheld, or rather, the leave to appeal was not granted, both at the SAA and the Constitutional Court. So that seems to be accepted, that if you are raising a Section 35(3), then you must do it at the end of the trial. So that's a double prematurity. Now, and this raises very fundamental issues, because there is a sense, whether we like it or not, that the law, when it's this one, it applies this way. When it's that one, it applies this way. And we should, that sense, whether it's correct or not, it should be dispelled, because the law is the law. It has no eyes. Justice is blind. It's supposed to be. So if, and maybe to emphasize this point before I go to the next point, this very Mr. Zuma, the former president, it will be remembered that part of the genesis of this whole thing is, you'll find that in paragraph 240 of the S versus Zuma, the Kuhn J judgment, is that this matter was raised squarely on the 21st of September 2021, actually. So that's another reason why this Nazareth theory is actually, something that one should not even entertain. Because on the 21st of September, what happened is that the former president said to Justice Kuhn, I'm not, remember this was now exactly a month before even laying the criminal charges, that I'm not going to, I'm not raising this point, I'm simply putting on record that I'm going to lay criminal charges regarding the leaking of my medical record, because it was now, there was no time to do it. A month later, indeed, he then laid those charges. Now we're told that all this prosecution was about Nazareth. Anyway, but the point I'm making now is that in that case, former President Zuma did it's not like he's saying to this applicant, do as I say, not as I do. He did exactly that in that case of S versus Zuma. He raised his challenge to the title to prosecute under Section 106(1)H in front of Judge Kuhn in the criminal court. That's what he did. And that's what everyone should do. There should be no exceptions. And that's how this whole thing came. And then in the course of all that, then the medical certificates and all that, and the facts, the court knows about that. It was actually in the postponement related to that very matter which he had brought in the criminal court, as he should, as everyone should. As we all know, it should be done. Even having done the right thing, his case was dismissed. Because they said, no, because you have to do it under Section 35, actually you should do it at the end of the trial, not even now. And now we're told, no, actually you must do it even before the plea stage. Because, I don't know why. So you cannot do that. It can't be done. Then the case, the matter was then followed again. So the tint approach was followed by Judge Kuhn. So where are we? Southeastern Cape Local Division, KZN, and then it was followed in this court in Musa. In Musa, the following was said, and you'll find that at paragraph 92 of our heads. So the principle, and then on the facts of that case, it was said that the accused did not make the connection, but the principle was said as follows, the underlined part of our paragraph 92. A private prosecutor is a person who meets the requirements of Section 7(1) of the CPA and continues with such prosecution. Such person will have title to institute a prosecution. The underlined part says, if such a person institutes a prosecution for an ulterior purpose, that will constitute an abuse of process which will affect the title of the private prosecutor within the meaning of Section 106(1)H. The same would apply to a private prosecutor that never complied with the criteria of Section 7 in the first place. It can't be clearer than that. If the prosecution relies on ulterior motive to challenge the title, as happened in this case, I read out the paragraph 92 or 91 of the heads of argument yesterday, of the applicant's heads of argument, which will affect the title within the meaning of Section 106(1)H. The title to prosecute can only be within that meaning of 106(1)H. Nowhere else in the law is it provided. Then it says the same would apply to a private prosecutor that never complied with the criteria of Section 7 in the first place. So that's crystal clear. And then in Mukhesi, subsequently in the Free State, that was the Ace Mahashule case. The court specifically, if you go to paragraph 38 onwards, and this is where I respectfully wanted to differ with your ladyship's differentiation, let's call it that, of Mukhesi. I accept, of course, that the facts are different and the legal grounds that were raised were different and the constitutional grounds were different and so on. The issue about self-incrimination and the fact that it's being heard in the Zondo Commission and so on. But Mukhesi said in so many ways, in fact, it's the one case that calls the spade a spade. Because it says this is preliminary litigation, and preliminary litigation cannot, must go to the criminal court effectively. And it says, if you go to paragraph 93, my lady and my lord, of our heads, I'll start with 43. It says, against this sketch of legal position, after talking about tint and so on, I tend to examine the relief sought by the applicant in this matter. The hallmark of all 4 applications is that the accused have not yet pleaded to the charges against them, yet each seeks declaratory orders without any evidence being laid against any of them. They have given no indication of why these challenges in respect of the charges and the evidence to be presented are being brought before this court, and not the court that will hear the trial, which is, to use the words of the court in Moyo, the constitutionally compliant forum. Each one appears to have simply ignored the provisions of Section 85 and other relevant provisions of the CPA, which is the constitutionally compliant statute, promulgated specifically to deal with all aspects of criminal proceedings. Again, lucid, clear, no deviations. And by the way, if I may just quickly get rid of a quick point, apropos, just to take advantage of the mention of Section 85 there. There was an issue raised by your ladyship about vagueness yesterday. And I gave one answer so that we won't deal with it when we go to the merits. I gave the one answer, which is that the principle of voidness and vagueness applies to legislation. The other reason why that is a bad point is because of this Section 85. Section 85 of that cluster, criminal lawyers know from Section 84 to 88, the clusters that deal with the charge. The gist, and I think it's 86.4, but I stand corrected. But the gist of that regime is that if any accused person feels that there is any vagueness or lack of clarity, then they must ask for further particulars under Section 85. So that's another, which is what they were saying here in Mokgesi. If you think, no, this comma should be there and so on, you go under Section 85.
In relation to the charge or to the nolle prosecute? Because the way I understand the applicant's case in relation to the vagueness point is in relation to the certificate and not to the charge.
Yes, but remember, the reason why you are here is to set aside the prosecution as such. And one of the things we are told is that they don't know well, firstly, and I'll come to that when we deal with the merits, they go as far as to say, on these facts, there could never be a conviction, which is absolute.
Okay, let me rephrase my question.
Yeah.
Are you saying the vagueness point should be raised in terms of Section 85?
Yes.
Sorry. It should be raised in under Section 65. The vagueness of the certificate. That's my question. Whether, if the applicant complains that the certificate is vague, then he should raise that complaint under Section 65.
All right. Now, I'll do a shortcut. The answer is that it doesn't matter which one it is, and so I'll just go to Section 80. Yeah, 80. Yes, it was. Yeah, so 86.4 says, the fact that a charge is not amended as provided in this section, in other words, if you wanted to cure something, shall not, unless the court refuses to allow the amendment, affect the validity of the proceedings they are under, okay, the entire proceedings. So whether, because that's really the point that brings us here, that the whole prosecution, because of ABCD, should be set aside. So the validity of the proceedings are not affected by such defects as may have required an amendment. That's the first thing. Then, to come to your question, if there's a defect just in the charge, then you go to Section 88. And Section 88...
No, but my question is not about the charge, it's about the certificate.
No, but The attack on the certificate is not an end in itself. The attack on the certificate is to say that this prosecution must be interdicted, should not be here, because one of the things is that the charge is, or rather the certificate is vague, and all the things that we have been told here. Okay, but the purpose of that is to say that the proceedings are invalid. Right. Right. Now, I'm saying and I'm acknowledging that there is a difference, as the question correctly separates, to a validity attack on the proceedings per se and a validity attack on the charge. And I'm saying that it makes no difference because the Criminal Procedure Act caters for both. As far as the proceedings are concerned, you'll find that in Section 86(4). But as far as the charge is concerned, you'll find it in Section 88, which says, where a charge is defective for the want of an averment, which is an essential ingredient to the relevant offense, the defect shall, unless brought to the notice of the court before judgment, be cured by evidence at the trial, proving the matter which should have been averred. So the answer is that whether you're talking about the charge, whether you're talking about the proceedings per se, the Criminal Procedure Act caters for that. And I was just wanting to get that out of the way because of the mention of Section 85 here. But back to Mokhesi. Back to Mokhesi. It said that okay, I won't read the whole 44, Mr. Muela read it. I'll just read the underlined part. It says the test, with regard to the two-stage test for whether a declarator should be granted, my view is that the test is applicable in civil matters and not in a matter such as this, which, and this is the key, which falls into the category of preliminary litigation relating to criminal proceedings. And so that's why they gave the characterization of what was before the court in Mokhesi, which is the same as what is, the facts might be different, but what the court characterized what was before them as preliminary litigation relating to criminal proceedings. And this is where we are now. So the latter, which is the case like this one, is regulated by the Criminal Procedure Act, with the criminal trial court being the correct forum to decide the issue in respect of which a declarator is sought in this matter. And the coup de grace is on the next page, paragraph 94 of Mokhesi, where the court said at paragraph 38, the court tasked with adjudicating a criminal trial is the forum which must be approached with regard to challenges or objections relating to criminal charges during the course of the criminal trial. Now, the irony of ironies is that this is now the fourth province which has followed this approach. But this takes us ironically to my learned friend's favorite case, which is Solomon, the 1950 case. Solomon actually is, as I indicated yesterday, okay, I'll find the note. I've got it here. Yeah, 616, page 616. Oh no, I think do you have Solomon in your bundle? Yes. Yeah. Sorry, I'll use my learned friend's bundle. It will be 027. 436. Thank you. Triple three. Thank you. Yes. Now, Solomon is the most abused case. That case, firstly, and I'll deal with the first point maybe when we deal with the merits on ulterior motive. That case, the first part that my learned friends want to rely on is against them for a different reason, which deals with the merits. Because that's the case which established the principle that you can only raise ulterior motives, even if you are raising it on its own outside of title to prosecute. You can only raise it if there is not, if it's not accompanied by an intention to get a conviction. In other words, it's irrelevant if it's just, so I can do it because I want to spite you and for all my ulterior motives. But if I also want to actually secure a conviction, that's the motive is irrelevant. That's the principle that we discussed yesterday that comes from the SCA case of Zuma versus DPP, which was confirmed in Riddell. So Solomon, that's all Solomon said. And again, Plascon Evans kills the applicant's case in that, because this court is enjoined to accept the version of the respondent, that he is here for a conviction. That's what he says in his affidavit. You can't cross-examine an affidavit. The affidavit says he wants a conviction because his rights have been wronged, and that's it. It has to be accepted, unless you can show that it's far-fetched or he's actually not concerned about the leakage of his medical information. It's actually vexatious, we are told, frivolous. That which one of us here would like their medical information to be flighted all over? But anyway, we're told it's frivolous. But anyway, he says, this is not frivolous. I want justice. I want everyone who has been involved in this, directly or indirectly, to face the law. If they're going to be acquitted, fine. If they're going to be found not guilty, fine. If it's going to be found that I don't have a title to prosecute, fine. If they're going to get off at Section 174, fine. But don't preempt the law. That's all he's saying. And the court in civil motion proceedings must accept that. And therefore, the idea of a Solomon type of case where there is no desire for a conviction gets out of the window. But, more importantly, Solomon tells us that, I think it's at 616, yes, so at 616 of Solomon, yes. It says Mr. Pollack, sorry, you'll find that at 027339, my ladies and my lords, page 339. Mr. Pollack here is Mr. Maneche. Mr. Pollack also took a point based upon the form of the Attorney General's certificate. Comes to your issue, my lady, where the attack is on the certificate now. This, he said, related to a charge or charges not against the applicant but against the applicant and Davidson. It shows the relationship that you can't really isolate. The charge and the certificate in this context is the same complaint, but I'm happy to have it separated. So this is said related to a charge or charges not against the applicant but against the applicant and Davidson. So in other words, the attack on the certificate is in effect an attack on the charge, because it says the charge is unsustainable or is against Mr. Downer or whatever. So Davidson here is Downer. And there was nothing to show that it related to the charges which the respondent now proposes to bring against the applicant. That's exactly Mr. Maneche's case. It says, the heading of the certificate, however, merely shows that the respondent originally joined Davidson with the language in Section 17 of the Act. Okay, that's the old pre-constitutional Act. There is no provision in the Act under which the Attorney General can be required to particularize or identify the charges on which he declines to prosecute. Very, very important. And we'll deal again with this when we get to the merits. This whole thing about what Advocate Zungu was thinking or read or did not read is the biggest mistake, but we'll deal with it when we deal with the merits. Because there's nothing there, actually, in Section 7, there's nothing that even says that you must identify anybody. It says the charge, right? And I'm tempted to deal with this, but I don't want to deviate again. But the point, let me do it now while it's still in fresh in my head. The point that we will make then is the following: that if, in terms of what you call accessory after the fact, if there are 5 people in a cell, a proper cell, not one where you can escape. And then one of them dies. Then the other 4 obviously are the people who killed him. He died of injuries. And then all 4 of them hide the body, as it were. And then they are charged as accessories, or rather they're charged even for murder. And the NTPP declines to prosecute. Knowing that he or she, the NTPP now, is dealing with these other 4 people. The fact that 6 months later, it's discovered, there were not 5 people in the cell, there were 6. So there's a 5th one. You can't now say, no, when the NTPP declined to prosecute, they did not have in mind Mr. New, because she was told that there were 4 people, and therefore the certificate doesn't apply to them. I mean, that's just absolute. It's a deviation from the most basic rules of what we're dealing with here. But anyway, I deviate. It says declines to prosecute. Now, the Roper J said 70 years ago, 73, if there were any suggestion that other charges than those now laid by the respondent had been made against the applicant, whether by the respondent or anyone else, there might have been substance at this point, but as it is, I consider it unsubstantial. If at the trial, and this is the most important thing, if at the trial the applicant can show that the Attorney General's certificate did not relate to the charges included in the summons, which is the exact case you are facing here, he will no doubt be entitled to his discharge with costs. Now, what does that mean in simple language? If Mr. Maneche is correct that the charges in the certificate do not relate to Mr. Ramaphosa, then he will no doubt be entitled to his discharge with costs. When is the discharge done? At the stage of Section 174 of the Criminal Procedure Act, as we all know. Then an accused person asks for a discharge. So in terms of, if you look at now from the prism of prematurity, this even worse prematurity than the 106 point, because it's so we have a Section 85 point, we have a Section 106 point, and we have a Section 174 point, and we have, can't remember the section when you convict. That's the one that Trenkov SC said they must either follow 106 or they must just plead not guilty and be acquitted at the end. He forgot the 174 stage. But for present purposes, that's what this case is. So, long before there was Moyo or Tint or whatever, the position was clear in our law from Solomon in this division that you must do this at the trial and you'll get your discharge at Section 174. So on what basis, on what conceivable basis can this court differ from all the divisions in this country, differ from the Constitutional Court, differ from the SCA, and say, oh, yeah. President. Does that mean we're on? Not yet. Sorry. My phone. Thank you very much. Yes. So, in sum, I'm saying, in Solomon, when there's issues to do with the charge and the certificate, and whether it's this one or that one, whether it relates to the person, the accused person was correctly sent packing to say, go and raise that and you'll be discharged at 174. In NEDCO, when the accused raised the title to prosecute, they were sent packing to say, no, you should raise that at 106. In Muhesi, when the accused raised the constitutionality of the charge, they were sent packing. And they were told, you must go and raise it in the criminal court. In Zuma, by Kuhn, he was sent packing to say you must raise it even at the end of the trial. And now here, for some reason, because we have Mr. Ramaphosa, the law must change. And his must be entertained. That's not right. Can never be. It certainly will not be justice. So the situation as far as preliminary litigation is well settled in our law. And it would be difficult, even in a case where somebody had actually pleaded such exceptional circumstances to overcome all this, let alone in a case like this where that has not been done. And we know that the only reason that in Moyo, Justice Wallace J.A. reluctantly, as he puts it there, because he was very minded to send this thing back to the High Court, but reluctantly allowed it to be decided because, as Mr. Muela correctly pointed out, we all know as lawyers, by the time a case goes to the SCA, it's probably 3 years or 4 years down the line. So he would have been doing what we call cut your nose to spite your face. Because if he had sent it back, he would actually just be adding to the delays. So he just said, well, I'll just deal with it, but this is wrong. It must not be countenanced. Right here, those doesn't apply. This is this thing. The charges are 3 or 4 months or whatever old. In fact, it's the exact opposite. Here, we should prevent that exact thing of the thing going to the SCA and what have you, and so on. And then we should be buying into or playing into the hands of a well-resourced person who just wants to, to play with the law instead of just going to court like everyone else. And if they are innocent, they'll be acquitted. Now imagine if all accused people would do this. They say, no, wait, you just wait, Mr. Magistrate. Every Monday morning there are maybe 10,000 people who appear in courts for the first time in South Africa. If they all said, no, wait, I just want to go to the High Court quickly. I'll be back. I just want, there's something wrong here, there's this comma here, this one doesn't relate, the interpretation, whatever. And then they all would come here and would constitute a court, and then 6 years down the line, once they've exhausted all the things, they go back to the magistrate. Say, oh, okay, now we're here. Anyway, so that's the end of that section. This case should just be dismissed on the basis of the authorities, on the basis of the law, and on the basis of not allowing the courts to be a playground for the rich. As was said by Wallace J.A., or those who can afford the best lawyers. Now, the other point, the last point we have in limine, is one that is on its own 2 feet dispositive. And that's the question of locus standi. So it's now. Sorry, on my hands. I'm sorry, man. I can't do this other than from here. Right. Even if this was the right court and all these other things that we have said didn't apply, what justification can be given for, okay, let's start here, basics, law 101. Everyone starts with law of persons. And on the first day of law school, you are told something you didn't know, that a person is not just a person. There's a person, and there's a juristic person, there's a fictitious person, and whatever. So let's start there. The applicant in front of this court is not a natural person. That's common cause. It's not a human being. That, well, it looks like I hear a whisper. It should be, if it's not. The applicant is called, at least in the heading, the President of the Republic of South Africa. That's it. That's not a human being. That's an office. It's an organ of state, nochal. In terms of Section 239 of our Constitution, a president is an organ of state. Minister is an organ of state. MEC, premier, whatever. So an organ of state is a fictitious person, and that should be common cause. Now, there's no doubt about that. All right? There is a reason why in our law you've never seen a case in all the law books from time immemorial that says state versus the president, or state versus the premier, or state versus the whatever, mayor. It's state versus Jones or Smith, who may or may not be a mayor. The reason for that is very simple. That in the context of, if you go back to first principles, why do we have criminal law in the first place? And that's why here we call it state versus, in America they call it the people, which is more appropriate. The people versus so and so. So the state, in that sense, in the criminal accountability sense, cannot sue itself, as it were. Can be the state versus the state. Because also the state, in that sense, cannot be punished. You can't imprison something called the President of the Republic. You can only imprison a human being, which is the purpose of criminal law. So, if there's any doubt as to who is here, then that doubt should be dispelled. Now, at the most basic level of standing, forget everything we've said about objecting, about jurisdiction and what have you. Assume the court has jurisdiction and so on. Who should come here and say, court, please assemble. There's a nolle prosecution certificate that applies to some person in the Free State, and now it's being applied to me. Please do this, stop this. Who should do that? It's the accused person. The accused person in those proceedings. Who is the accused person here? Well, there's no doubt as to who the accused person is, because the accused person is spelled out in the other heading. So you must take two headings. There's a heading to these proceedings, President of South Africa versus Mr. Zuma, and there's other heading to the summons, and it says Jacob Zuma and Cyril Ramaphosa, the accused. And by some fiction, there's been a transformation where the accused is metamorphosized into the President of South Africa. It's not done because in criminal law, first principles, there's something called criminal capacity. And you'll find the definition of that in paragraph 50 of our heads. Snyman says it like this. Only a human being can perform an act as the latter term is understood in criminal law. There is an exception to this general rule, as always. A corporate body can also, in certain circumstances, engage in conduct and be liable for a crime. The law distinguishes between a natural person on the one hand and a legal persona, juristic person, corporation, or corporate body on the other. Very, very simple. The only exception, as the law always has exceptions, to the general rule that only a human being can perform a criminal act is provided for in section 332 of the Criminal Procedure Act. That section says that in the case of a corporation, a body that has been incorporated, a company, a fiction can be created where the director, in fact, ironically, that's exactly what happened in the case of Mr. Zuma, the one in the Maritzburg. The two accused there. Accused number 1 is Mr. Zuma, accused number 2 is Thales, sorry. And whenever we go to that case, there's a person sitting next to former President Zuma who's a director of Thales, a representative of Thales, because the company can't sit in the dock, as it were. So that's the only exception that's allowed where a fictitious person can be accused. There's no such exception for presidents or organs of state or other entities like that. So that's what's wrong. It's obviously wrong with this picture. Assuming all the rights were violated as alleged, they must be asserted by a particular person. Now, you have to get my file, the one like this. Yeah. You have to commend my learned friends for what I will call creativity, because you will be surprised to learn that it was not 709, sorry. It was not us who first raised this point, it was them. But when they realized its implication, they quickly kind of, I don't know, kicked it under the table. When the summons was served, on the 17th of December, 2 days after the summons, they wrote a letter complaining about all sorts of things. The first paragraph, which I want to refer, I'm sorry, you'll find it at 001-200. Yes, 706 and the old numbers. Number 1, we act for the State President of the Republic of South Africa, Mr. Matamela Cyril Ramaphosa, the President. 2, it has been brought to our attention that on 15 December 2022, a purported summons was served at the President's personal residence on behalf of your client, Mr. Jacob Zuma, and then all the complaints. But according to them themselves, it's been brought to their attention that it was served at the personal residence, which, by the way, is why we're here. If the accused person was the president, we would have been in the court in Pretoria. But it was served at his personal residence here in Johannesburg. And then they go on, and then they did not include a prosecution that relates to him. But go to page 202. That's where they say the indictment at 6.1 appears to cite and accuse the president as if he were a private individual. Then they say this thing about the indictment against the office of the state president, which the president is the current occupant. The indictment is clearly premised on the alleged failure by the office of the state president. Quote, and they quote from the actual indictment, to take or follow up any of the undertaken action and or institute the requested inquiry against any of the officials and state functionaries complained about, thereby making himself guilty as charged, and summons and indictment to which the summary is attached. Then they say, in any event, the alleged conduct does not constitute a criminal offense. That aside, the President's power to institute an inquiry flows directly from the office of the, and does not lie in the hands of the President as an individual. Service on the President at his personal residence and as an individual, clearly every evidence is a failure to respect the institutions created and supported by the Constitution of the Republic of South Africa. Here's the part, 6.6. This miscitation and misjoinder is also a fatal defect in the indictment, and we reserve the right to take all the necessary steps in regard to both these matters. So they say that this is a miscitation because it has been served on him, and it's a misjoinder, more importantly. What does misjoinder mean? It means that when you complain about joinder, you either, it's usually in the form of misjoinder or non-joinder. So they're saying, but by using the word joinder, you're talking about more than one person. So they were acknowledging that, okay, the President may be miscited or misjoined, quote unquote, but joined to who? Joined to the real accused. Now, we say that actually it's a non-joinder. And we gave them free legal advice on this. We said, okay, so that we don't have to be debating this thing about whether it's the President as an individual or the President as an organ of state, join him. That's all they should have done. Oh, honestly, that's all. They should have just said, okay, we don't agree with you, we just want to be intransigent. So therefore we'll have two applicants, the President and Cyril Ramaphosa. They would have silenced us. Because then we could have raised the point, but we could succeed, quote unquote, in respect of the President. But then the court would say, well, but the other applicant is here anyway. They refused flatly because they wanted to be to use the state attorney's money to bring this matter. So we said no. The reason why this thing was served at the private residence, and my ladies and my lord, I'm sure you'll remember, I don't have to take you there. The 15th of December summons, you will remember that it was sent to a law firm called New Penn Harris and something, which are the personal lawyers of the President. And that was done for a reason. Because A, it was being served, he was being accused as a person. Because remember, the case of the former president, and again you have to accept this, his case is that this whole failure to pursue the malicious distribution of his and criminal distribution of his medical information was driven by the personal animosity. Mr. Maineche referred to that section. And whatever personal animosities might exist or not exist. But it was targeted at, okay, let me put it bluntly. If the medical certificate and the medical information that has been bandied about was of any other president, if it was of former President Mandela or former President Mbeki, nobody alive with a brain would not think that that is such a serious thing. No one. But no, because it's former President Zuma, who's a plaything for the media and those who want to vilify him. All of a sudden, we just don't know that in any country, whether it's Bill Clinton or whoever, who can take the medical information of a former head of state and just splash it around, and then say it's vexatious when they complain. But I don't want to go there. the point is that the president then surreptitiously, literally, I mean, I wasn't there, so I don't know what happened, but we can imagine, receives summons at his house, addressed to him, CC care of his personal attorneys, and literally takes them to Pretoria and says, this must be taken to the state attorney and they must pay for me. And when we say no, but you must also join at least as an accused, we say, no, I don't want to. The courts will find a way, you know, or my advocates, expensive, I don't know, the best lawyers that money can buy, will find a way.
Sorry, I hope you're minding the time, because you're still dealing with the Lucas standard point. Okay.
And I think we can deal with that issue at the correct time. Let me put it like this then. What you call the 42.2, Mr. Manager also quoted this, 42.2 of our heads. The pleadings are clear at least. It says, I'm an adult male and the president of South Africa. I'm cited in a purported private prosecution. Let's stop there. I'm an adult male. The adult male is Mr. Ramaphosa. And the president of South Africa, we don't doubt where he works. And then he says, I'm cited in a purported private prosecution, which is true. But he's cited as an individual, according to his own letter. Now, again, an example of what we now colloquially call Zuma law is that when this very same situation arose in the case of Zuma versus DA, which is 2021-5 SA 189 SCA. The Supreme Court of Appeal said at paragraph 34, can you find it here? It's at the end. 34. Okay, 027-471, if we use my learned friend's, yeah, it's the one that's flagged, sorry.
027?
471, my lady, but I'm taking you to 477. The court there said, the Supreme Court of Appeal, Mr. Zuma and...
So give me the item number.
I'm sorry.
What's the item number? Okay.
Paragraph 34.
No. When you look at on case lines,
Oh,
where you have 027, then there each case that's filed there is given an item.
That was ended up yesterday. Yeah, I'll answer that.
It would assist me to be looking as you read.
Yes. But okay, for now,
027, number 20, item 20.
20, I'm told.
It's 027.
Okay, thank you.
027, item 20. Mr. Zuma argues that the state attorney was authorized by either section 3.1 or section 3.3. Let me just pause there. We accept Mr. Manager did say that this case had something to do with the state attorney also hiring a third party, Mr. Halley's firm, I think, and so on. But that's irrelevant for the purpose of the vote. Whether the state attorney is paying directly or through some other law firm, it doesn't matter. The point is that is the authority of the state attorney. It says, Mr. Zuma argues that the state attorney was authorized by either section 3.1 or section 3.3 to appoint and pay private attorneys to represent him. However, neither section authorizes the state attorney to cover private legal costs. So that's the point. to cover private legal costs, whether they cover them via intermediaries or whatever. They provide only for the provision of services by the state attorney. Section 3(1) of the Act reads, quote, "The function of the office of the state attorney and of its branches shall be the performance in any court or in any part of the Republic of such work on behalf of the government of the Republic as is by law, practice, or custom performed by attorneys." Not on behalf of somebody who happens to be a government official. That section authorizes 33, the state attorney to act on behalf of the government and to perform the work ordinarily performed by attorneys or for other legal representatives. Purpose of the section is to give the state attorney a legal mandate to act as a government's legal representative. Mr. Zuma was, I'm just jumping to the words, Mr. Zuma was cited in his personal capacity as it is in the summons. The orders sought would have been enforced against him personally, similar here. The person who would be imprisoned for 15 years or whatever it is Mr. Ramaphosa personally. Not against any government office or department. The fact that Mr. Zuma held high office in the executive does not mean that in representing him, the state attorney was acting, quote, on behalf of the government. And then it says, if you jump to 33, 34. In relying on section 3(1), the presidency and the state attorney appear to conflate when a government official acts in an official or representative capacity with that of an official acting in his personal capacity. There has been no suggestion that Mr. Zuma was advancing any government interest or purpose. Prosecution was instituted against him in his personal capacity. Thrust of the allegations against him is that he used his official position and influence in government to advance his private interests. The private interest that one would advance if they were acting out of personal animosity. And then it says that Section 3 permits the state attorney to perform the same functions or in connection with, we'll come back to that phrase later, in connection with any matter in which the government, though not a party is interested, is concerned in connection with any matter where the opinion of the state attorney or any person acting under his authority is in the public interest, and so on. And then here's the test of a government or public interest under Section 3 cannot be reduced to whether the person requesting the legal assistance currently holds or held a high office in the government. And then it points out that Mr. Zuma he was not even in government at the time, and so on. Then it says 39, but current is covered. 39, Mr. Zuma argues that the state has an interest in, quote, protecting a government official. That's what Mr. Maneche was telling us. But this is not necessarily so. The government and the public have an interest in protecting the rule of law and ensuring accountability and good governance, all of which is achieved by prosecuting offenses of corruption and other abuses of public office, and by ensuring that criminal trials proceed without delay on the Moyo issue. Whether the government or the public has an interest for the purposes of providing legal assistance by the state attorney's office must entail at least an assessment of the nature of the proceedings, the issues arising of determination, and whether there is a legitimate reason for government to support a position taken in the matter by a party other than government. A party other than government. So even there, it's accepted that, let's assume there was another party. So the non-joinder or the misjoinder is assumed to have been cured. I dare say the government and the public can hardly have a legitimate interest in supporting a defense against criminal charges by an incumbent or former public office bearer, and especially not in respect of charges of dishonesty and corruption, or the kind of thing that the president is accused of here. Allowing officials to resist being held accountable by drawing on state resources to obstruct or delay a prosecution subverts the government and the public's interest. But that only seemingly applies to former President Zuma. But fortunately, the SCA judges said included incumbent in that. So there's no basis upon which A, there is a locus standi for the organ of state. And in any event, by the way, there's a case of Mapolisa, which we just uploaded. It's fresh from the box. It's from the law report of May. It's on 077-539. It's a judgment of Mali HAA. I'll paraphrase because of time. At paragraph? Oh, it's on item 9, but I'll refer the paragraph. The gist of that case says that just as it was held in Sita versus Gijima, which we all know, that an organ of state cannot bring a Paja review against itself, that principle applies to an organ of state, like here, which seeks to invoke Paja against another organ of state. So from that point of view, from the authority of the latest case in the SCA, in any event, the reviews that are based on all these things, Audi alteram partem and all sorts of things, should be kicked out on that basis alone. But that's just related to, in other words, to put it in legalese, an organ of state does not have locus standi to invoke Paja against another organ of state. All right. Now, that takes us back to the merits. So the point we're making is that for the prematurity, jurisdiction, locus standi, those are dispositive of this matter. That should have been the end, which is why we had asked the court to deal with the points in limine separately, because they are clearly dispositive. I don't think anyone can argue against that. But as you know, we also put a proposition against ourselves, which is that in terms of the Jordan principle and Saripa principle, another court might want to hear, even ex abundanti, what the take of the court of first instance is on the merits. And so we go to the merits. Now, the merits, really, I don't have much to say. We've covered the gist. I'll do it in point form. Let me first get rid of the other issues that get thrown in. It's the AK-47 approach. Just spray and hope to find some target. One of the issues that is raised is, and I don't know if it's seriously raised, is that the registrar should not have issued the summons. I mean, I don't think that's worth even 1 minute of this court's time. And that is purportedly done under Section 7(1)(a), I think. No, Section 7(2). 2B. That section does not even mention the registrar. It's got nothing to do with the registrar. That section talks about the duties on the public prosecutor. Where's the big book? Thank you. Sorry. Section 7 says, 772B, the attorney, yes, 2A, sorry. No private prosecutor under the section shall obtain the process of any court for summoning any person to answer any charge unless such private prosecutor produces to the officer authorized by the law to issue such process a certificate signed by the Attorney General that he has seen the statement or affidavits which the state is based and that he declines to prosecute at the instance of the state. Now, all it says here, and I think this was explained in Nandalal, is that the registrar doesn't have a job to say, oh, does this certificate relate to this person, and so on. Let's take a ridiculous example. If you are charging a 13-year-old and you put a summons to the registrar's office, And we know that a 13-year-old is duly incapacitated. It's not the registrar's job to say, no, but this person is not capable of criminal capacity. The registrar simply says, is there a nolle prosecution? Is it issued? Is it whatever? Is there proper summons, the form? And that's it. You'll go and argue in court whatever you want to argue. It's not for the registrar to say, no, you don't have jurisdiction. Should have brought this in Cape Town or what. So here the public prosecutor has obtained, the private prosecutor at least, the certificate, and it carries with it the guarantee that the DPP has seen the statements and affidavits. That's it. And we know that here it does. So, and the registrar then came up with something to say there was a clerk who doesn't know the law. All that is irrelevant. So I don't think we should take that seriously. Then the next and related problem, which can be disposed of quickly as well, is the one of security. Mr. Manecha correctly, I think, was minded to abandon that until I think Justice Ismail reminded him. And he said, well, he wanted to advance his better points. I don't blame him. But that's for two reasons. One is that as it happens now, the security was paid. Mr. Manecha says that, I hope I'm not misquoting him. He says he does not remember that the Justice Sutherland condoned the non-compliance. Well, that's very strange because in the affidavit of Mr. Ramaphosa, it's admitted that there was such a condonation discussed with Justice Sutherland.
Do you have a reference?
Yes.
That admission?
Okay. You can find the answering affidavit. It's the thing we found yesterday. All right. I know it's page 122. It's paragraph 122 of his answering affidavit, but I'll get the case line reference. So it's strange how Mr. Ramaphosa was not even in the meeting with the DJP or in court when the condemnation was discussed. Knows that it happened, but the people who were there don't remember. But be that as it may, what we say, we raise this issue because we knew that this is going to happen. Okay, can you get me the composite as well? Yeah. In the Heli Valley of Agent Court, what actually happened is that we're still standing all here. The court said there were two issues of non-compliance. Ironically, the one that was raised as an example by Justice Ismail. The other side had an affidavit of Mr. Ramaphosa that had not been commissioned or the address was not there and so on. And we took the point that then it means there's no application because they're not here. And they asked for substantial compliance, the usual story. Similarly, we acknowledged that the security had not been paid and we showed the efforts that had been made and asked for substantial an order for condemnation on the basis of substantial compliance. And the court said, before we start, we want to make it clear that the issue of the affidavit and the security, those condemnations are granted. Let's get on with the issue. Now,
Was this in court?
yes, in this room.
Is there a court order to that effect?
No,
because I've not seen.
If there was, I wouldn't be even addressing you. I would just hand it up. I'm saying, let me just, if I can just give account of what happened, please, Justice. Then let me start by saying, again, we assume because of the Heli Valley of Agent Court, that was not reflected in the court order. But knowing what we are dealing with, we wrote a letter. Where's the? Can me the joint the attachments to the... I'm sorry, I'll give the references later. We wrote a letter on the judgment was given on the 16th. Then the DJP convened a case management meeting on the 18th, as he had undertaken, because he wanted to give us an expedited hearing. We wrote a letter which I'll read out if I have time, but I'll paraphrase it now. Fortunately, it was a joint letter, so no one can dispute it. A joint letter from the parties. In that joint letter, we said, our contribution to that joint letter was to say the issue of the security of the condonation was not reflected in the court order. And we want to highlight that issue. I can't remember the wording now. But more importantly, because the order says you cannot do anything, if we now go and pay the security, are we going to be in contempt of court? And so that was then raised in the meeting that Mr. Manager does not remember. And the DJP again said there, yes, thank you, before I start, I've received the letter, and I want to make it clear once again that I can see the technicality of that there might be seen to be contempt of court. That issue was dealt with in open court. The fact that it's not in obviously he couldn't go and redo his order is water under the bridge, but you may take your steps. Don't worry, you won't be in contempt of anything.
Mr. Mpofu, it's proper for your attorney. I require an order.
Yeah.
If Judge Sutherland, DJP Sutherland, granted an order in relation to condonation for non-payment of security, there should be an order to that effect.
Yes.
Your attorney is entitled to approach his office to obtain that order. Yes.
That's fine. If the court is entitled to whatever the court is entitled to. I'm saying as far as the parties are concerned, the parties were here, the parties were in the meeting that I'm talking about, and the parties were in a subsequent meeting when we appeared in the court of Judge Ismail, in the criminal court, where again, at least in that matter, on that day, Mr. Manager was not there. It was his junior, the registrar, and myself. And we met on the 5th floor at the office of the DJP. And he again reiterated to say, as far as the issue of security, you'll remember our arrangement and so on, and that was done. So, but if the court is not prepared to take that from the bar, or at least from a joint letter also written by all the parties, well, that's another matter. But the point I'm making is that the issue of the substantial compliance in any event, even if it were to be brought back here, is that compliance has actually happened. And the case of ACDP in the Constitutional Court says that when condemnation on the basis of substantial compliance is sought, the purpose of the statute has to be seen. You'll remember that was the case about the political party that had not paid the deposit, which must be paid before an election and so on. And it was, even though strictly speaking they were not, that means they could not stand in the election. It was found that there's substantial compliance. So it was the same principle that we had invoked, actually using that same case. So the point is, what is the purpose of this? The purpose is to cover the applicants so that when the trial happens, they will have security to be able to claim costs. The trial has not started anyway. The security has been paid. So if you look at the purpose of the section and the fact that the security has been paid, to try to now come back and say no, well, you paid it late and therefore you're out, would be draconian, to say the least. So that's the so whether one recognizes the condonation that was given by Sutherland DJP or works on the facts before the court now, which is that the security has been paid, the result is the same in our respectful submission. And this is not an issue that should detain this court. it's common cause now that again there was a meeting with the registrar sometime in April, I can't remember the date. The registrar fixed the amount, in fact fixed it higher than the amount we were asking for, and said it must be paid within 7 days. It was paid within 7 days, and that's really what has happened. Okay, let's move on then to the other points that is raised. Well, because of time, I'm not going to debate this issue about, oh, by the way, sorry, it's very important. This whole thing about security might just be of academic use anyway, because if you read the section properly, security is not required in this, but we decided to pay it ex abundante again because we know what we're dealing with. But section 9 of the CPA says, no private prosecutor referred to in section 7 shall take out or issue any process commencing the private prosecution unless he deposits with the magistrate's court in whose area of jurisdiction the offence was committed, the amounts and so on. Now, this applies only when the private prosecutor himself or herself has issued the summons, which is not the case here. Here, the summons was issued by the registrar. Now, if you go to Rule 54 of the Superior Courts Act, so I cannot call it up. You'll find that it's a rule that permits for this court, for some reason, actually I didn't notice this before. In every other province, the summons in a criminal matter, whether it's a private prosecution or not, can be issued by a policeman and all sorts of people. But if it's a private prosecution, it can then be issued by the prosecutor himself. But it says, except in the Witwatersrand local division. I still can't work out why. Where in this division, you have an option to issue it out of the registrar's office, right? So once you've taken that option, in other words, deviated from the option in the Rule 54 of the Uniform Rules of Court. You got it? Okay, thanks. Yeah, the process 54.1. The process for summoning an accused to answer any indictment shall be by writ sued out by the chief clerk to the Attorney General who presents the indictment, or in case of a private prosecution, by the prosecutor or his attorney, which would be hit by Section 9, and shall be directed to the sheriff, provided that in the case of the Witwatersrand local division, the writ may be sued out of the office of the registrar of that division by the Deputy Attorney General of Johannesburg or whatever. So anyway, the big point is simply this: if the prosecutor issues himself or herself the process commencing a private prosecution, then security is required. But that's just to say, in any event, even if the section applies, it's been complied with substantially. Now, I'm not going to entertain the issue about whether it's the certificate of the 6th or the one of the 21st. Mr. Matibeti's point that, which is also wrong, but which is also latched on by the applicant, that because the certificate of the 6th of June, because the summons was issued out in December, it had lapsed. That's completely wrong. The section is very clear that a certificate lapses unless prosecution is actually instituted within 3 months. And here, prosecution was instituted within 3 months on that certificate. So the certificate did not lapse. I mean, it's very simple. So and you can't say the certificate, it's either it has lapsed or it has not lapsed. It has not lapsed because it has, if you use lawyers' language, interrupted by the prosecution which took place in September. So that's a non-point. But all we're saying is that, and we agree with Mr. Mativedi, I think, and also my learned friend, this court does not have to get into that because it doesn't really matter. The certificate that is invoked in this prosecution is the certificate of the 21st. There's nobody who can doubt that. That certificate is, if you like, it's part of the history of the matter. So obviously it's part of the history, but whether it has lapsed or not lapsed is completely irrelevant for the purposes of this prosecution. Similarly, with the issue of the question of the summons, whether it's the summons of the 15th or the one of the 21st of December, it really doesn't matter. Because all that happened is that on the 15th of December, a summons was issued with a nolle prosequi, the one of the 6th. Let's assume for present purposes, it could be argued later that it had expired. But it was there. And even in the summons, it says with the nolle prosequi of the 21st of November. But for some reason, it was not attached. So when that point was taken, a letter was written. We said, okay, we'll just reissue, we'll amend it and reissue with the one of the 21st. So again, for the purposes of this court, you can ignore whatever happened on the 15th and look at the summons of the but it is part of the history of the matter. You can't ignore it at that level. But for purposes of validity, the 6th certificate, 6th of June, and the 15th of December summons can be wished away, as it were. Now, let's come to the more serious business. Those things about vagueness we've dealt with. Audi, I think we've dealt with. It's out anyway because it's Paja related because of the Mapolisa case. Oh yes, yeah. I think I did say that. Yes, but let me, for emphasis, that the condonation of the security was done in the same breath, literally, with the condonation of the affidavit, founding affidavit. So it will be very strange if Mr. Maineche's team wants to embrace the condonation of their affidavit on the basis of substantial compliance, but eschew the simultaneous condonation of the security point. Thanks. And in Nandalal, anyway, it was there. I think it was a question of the signing of the summons by the private prosecutor, and the court said these people, they know each other, they can sign it afterwards because it's, you know. Anyway, so that gets rid of those. Then there are two issues left, and one of them is important for multiple reasons which we discussed yesterday. The ulterior purpose question is important for two very important reasons. Three, actually. The first one is the Solomon's issue. It's out on that basis, as I've discussed earlier. The second one is the fact that in this case, it is tied directly to title to prosecute. We discussed that as well yesterday in my exchange with Justice Pan. And therefore, there's no doubt that we're in 106, Section 106 land. But the more important one is this, is that it gets rid of the interdict. Let me explain why. If the court is with us on the issues of the ulterior motive, also because of the lack of merit in the so-called Nazareth theory, then automatically the interdict falls away. The interdict falls away for the reasons that were articulated by the court yesterday, which I won't go into, which Mr. Maineche, I think, considered, kind of. But, all right, well, he didn't put up his usual robust resistance to. Because the court was right, and he knows that it was right. But the court is right because, A, this so-called right, nebulous right that they concoct, they have a right not to be charged on an unlawful certificate and whatnot. That so-called right, when it's pitted against Section 34 in Nandalal, which is the right of the private prosecutor, and in Section 7 to assert his rights, that's a right we all know. It will pale into insignificance, even if it was there. But more importantly, and I think it was Justice Mudiba who raised this point, which I'm going to add to. The issue of alternative remedies in the context of the PAJA in Section 179(5)(d), where the hearing in any event would have been given. But more importantly, we've all been debating one thing here and one thing only, that there is a remedy in Section 106. The only possible debate was whether is that the only remedy, and or is it compulsory. But that there is an alternative remedy under Section 106 is common cause with everyone. So that when you're talking about interdicts, that's a killer. You can't, the absence of an alternative adequate remedy is essential. Here we've shown that the other remedy is not just adequate, it's actually better because you get an acquittal. So how can you get an interdict? But the most important thing is that the interdict in this particular case is twinned literally with the ulterior motive ground. In other words, they're saying because there's an ulterior motive, because of Nazareth and what have you, then you must interdict. So once the roots are gone, the tree must fall. So if it's rooted in the Nazareth theory, among other things, then it must die together with that. So then the interdict is a non-starter. In any event, I've never heard of such a thing. It's worse than preliminary litigation. Not only must you have preliminary litigation and stop a prosecution, but you must stop in perpetuity that the former President Zuma, even if, let's assume the issue was security, even if he does pay the security, or even if he gets and I think that's the point Justice Parker made, even if he gets a compliant nolle prosequi and so on, he must just be non-suited forever. Amen. What is that? So the interdict is a non-starter, which then leaves us with the one issue in this case, which is the issue we debated yesterday. And I asked the court to consider the issue I raised. And I'll raise it now in cryptic form. About whether the certificate relates to the person. It's a misnomer to ask the question in that fashion. As much as it is a misnomer to want to ask an interpretational question by asking what Advocate Zuma did or did not do. The leading case, my back. Sorry. Yeah, sorry. Yes.
Please round off. We've gone into our tea time now. I don't know if you're aware.
So what must I do? I have to deal with the main issue. We can either deal with it now or after tea. That's the issue that we were busy with yesterday.
I'm asking you to round up.
Okay,
Yes.
thank you. Now, okay, let me do it like this then without... The approach that seemed to be followed is dangerous. The one that asks about what did Advocate Zuma do or did not do. Because it slides us back into the abyss of intentionalism. Intentionalism is the old-fashioned approach of interpretation, where the so-called intention of the legislature or the intention of the parties and whatnot, which is an artificial, it's shown by Wallace J.A. in domain, that's just, those are fictitious things anyway. And the reason why our courts have, in the modern way of interpretation, have moved away from intentionalism to the purpose driven interpretation is exactly to run away from the subjectivism that is associated with the intentionalism. Okay, that's just the theoretical basis. But the real thing is this. When you are interpreting a document or any instrument, legal instrument at least, then you have to follow what was said in paragraph 18 of Natal Joint Municipality Pension Fund versus End Domain. And it says, over the last century, there have been significant developments in the law relating to the interpretation of documents, both in this country and others that follow similar rules of our own. It is unnecessary to add unduly and so on. And then I'm jumping. The present state of the law can be expressed as follows. Interpretation is the process of attributing meaning to the words used in a document, be it legislation, some other statutory instrument or contract having regard to the context provided by reading the particular provision of the provision in the light of the document as a whole and in the circumstances attendant upon its coming into existence. Whatever the nature of the document, consideration must be given to the language used in the light of its ordinary rules of grammar and syntax and context in which the provision appears, the apparent purpose for which it was directed, and the material known to the responsible for its production. Where more than one meaning is possible, each possibly must be weighed in the light of all these factors. The process is objective, not subjective. A sensible meaning is to be preferred to one that leads to insensible or unbusinesslike results and undermines the apparent purpose of the statute. I'm not reading the rest. It's known to the court. What has that got to do with this case? If you want to answer the question whether a nolle prosequi certificate relates to a person, you don't go and say the person who did this. It's like a certificate is a certificate. It's like a birth certificate. You don't say, oh, let's find the midwife who delivered the baby. The certificate is the certificate that says that it says what it says. So you must then interpret the certificate. What does it say? It says the person was born on such and such a date in Bloemfontein and to these parents or whatever. That's what is known as a certificate. So what does it certify? It certifies that the DPP has read the documents, has read all the documents, and unfortunately because of time I won't show you how many times Mr. Ramaphosa is mentioned there, which is what we did overnight. But she says that she has read all those documents and she has decided not to prosecute any person in connection with the matter. Right? Now, the job of the court is to say, is this accused person or anybody who comes here hit or not hit by this certificate? And for that, you have to look at the rest of the documents around it. The certificate, the complaint document, the affidavits, and the nature of the charge, and so on. That's what is called the legal context within which, and what is the purpose of the document, which is to certify to the world that the DPP will not prosecute on this. Now, that exercise is meant for various reasons, and maybe let me do it like this to make it make sense. Let's assume for a minute that the state, we know this will never happen, but let's say that tomorrow the state woke up and said, what? We're going to charge Mr. Ramaphosa for aiding and abetting or the the alternative charge, which, by the way, nobody has spoken about, because even if the first charge was gone, the alternative charge is still there, but that's a debate for another day. Let's say they say they're going to do that tomorrow. The question you must ask yourself is, would that prosecution stand? Or would Mr. Ramaphosa be entitled, as I would argue that he would be, to say, you cannot prosecute me for breaching Section 41(6) of the NPA Act in aid of Mr. Downer. And we'll say the ones who want to prosecute him. Why? Let's say I'm now the prosecutor. He says, I have a certificate here from the DPP who says, I will not prosecute any person in connection with this matter of Downer leaking the documents. That's it. He must walk. So why then is it difficult when it's the other way around? That all we are saying, we can't say, no, but when she issued that certificate, Mr. Ramaphosa, she didn't have you in mind because she had not yet read the thing properly. What is that? What has that got to do with anything? The point is that when she made the decision not to prosecute in relation to that matter, then that's how the court must read that document, not to prosecute. And anybody who wants to say an accessory after the fact to a murder is not connected to the murder needs their head to be examined. Because the word in connection with has been, and again, we might send a note maybe to the court later about the cases of Robinson and various other cases. And the latest one is Alex Kor versus Rechtersveld. This is Rechtersveld. At paragraph 30, I'm sorry, it's not, is it? Oh, it's on 077. Sorry.
You have consistently ignored the directives I've given regarding time. You have consistently ignored the directives I've given regarding time. I've asked you to round up. It's now 11:30. You were supposed to have finished at 11.
Thank you.
It's up to you. We should have now.
We should have. Okay. We'll adjourn until 11:45.
All right.
SABC?
No, Mr. Pofu, your time is up. No, Mr. Pofu, no.
I'm not proceeding with the argument. Can the court just listen to me at least?
Yes.
Thank you. Thank you, my lady and my lords. I've asked Mr. Ngalwana to give me this indulgence, which I hope the court will give me. I have instructions from my client to lodge or to raise an objection or a complaint regarding the issue of the shortening of the time for the hearing of the matter, which has then resulted in his prejudice in terms of delivering his case. And he has asked me to convey to the court that, to his understanding, the matter was, at his request at least, and as jointly agreed by the parties, the matter was set down for 2 days. And then a few days ago, the parties agreed as to that the matter would be finalized for over 2 days, not 1.5 days. And he learned this morning for the first time that it would be shortened to 1.5 days. I've explained, obviously, as I should, that it's the court basically makes up all the final decisions, but he has asked me to raise this point, and also to say that when he agreed to the order that was granted by Sutherland DJP on the 18th, which gave us the 2 days that he requested, and when he agreed to the joint practice note as well, it was on the understanding that that is the time that would be taken, and that's why he traveled all the way here and cancelled all his engagements for today. That's the first issue. The second issue is that also when the joint practice note was agreed, he agreed on it subject to the right of reply on the points in limine, which was agreed by all the parties, and which it's not clear whether that's going to be revoked, but it looks like there's a threat of revoking that. And so that he feels that the court, at least since we're here and everyone had agreed until this morning that we're going to be here, that time should be used for him to ventilate his case. So I suppose with that complaint goes with a request for time to round up his argument, because this is a very important matter for him, and he specifically asked me to convey the fact that in his view he has never seen something like that, and it's a manifestation of what he calls Zuma law, and he would like to register that, but I suppose for the rest, as a messenger, I'll leave it to the hands of the court. But I've been asked to convey that in the strongest possible terms. As the court is.
I'm going to give the others an opportunity to respond.
Mr. Manager, yes.
There is something we wish to place on record.
Yes.
That the times that the parties agreed for the allocation between the parties has been adhered to. We finished our argument in 2 hours.
Yes.
Yesterday, I did. And my learned friend, Ms. Muvango, will finish her argument in the time allocated. We'll divide it up the reply time. That's the first. And we don't believe that there has been prejudice to the time that has been allocated to any of the parties. How a party uses their time is up to them. The second point we also want to record is in the practice note where for the first respondent it was recorded that he needs a time to reply on the points in limine. We recorded that he does not have an automatic right to reply. So it is not correct to suggest that it was agreed by all the parties that the first respondent will have a right of reply in respect of the points in limine. That's all I wanted to place on record. Thank you.
Okay, Mr. Mpofu.
Yes.
I'm not with you. I've got to hear other
Oh, yes,
counsel.
I'm so sorry. Yes, that's correct.
Mr. Motibedi.
This is the court. What I can only indicate is that I also kept the time that was allocated. And with regard to the complaint by Advocate Mpofu, I have nothing to say about it.
Thank you, Mr. Kalwana.
This is a spat among the parties. We want nothing to do with it. Thank you.
Thank you.
Thank you. May I
Yes.
proceed? Yes, thank you, Madam. Well, firstly, there's no complaint by Advocate Mpofu. Let's get that out of the way. They have made it clear that I'm conveying the instructions of my client. So I think that takes care of Mr. Matibedi. As far as Mr. Manech is concerned, I think maybe he didn't listen to what I'm saying. The complaint is not so much about that the time agreed was not granted. The issue is, and I indicated this morning when your ladyship gave the directive that the parties had already had some discussion, but obviously it was overridden by what we were told is going to happen. And between that time when the court addressed us and told us that we're going to spend 1.5 days instead of 2 days, the first time I was able to talk to the client was during the tea break. So there's no other time at which this could have been raised, by him at least. So that's the first issue. The second issue is that because the parties had agreed as to how to, if you like, reallocate the time, particularly in view of the fact that Mr. Matibedi had indicated to the amicus and I that we could use up his time, then, as I say, all that was overridden by what the court said when it came here, which obviously as practitioners we had to adhere to. So that's the point, because had the agreement of the parties or arrangement, I don't want to elevate it too high, or rather had the intervention by the court not happened this morning, then the first thing I would have done would have been to advise the court as to what had been arranged as between the parties. So that's the nub of the complaint. It's not so much about the quantum of the time. It's the fact that had that happened, then the client would have had an opportunity to finalize his argument. So the only intervening fact that made that arrangement to fall away was the shortening of the duration from 2 days to 1.5. That's really, I don't know if I'm making it clear. So whatever we address, let's not address a problem that is not the one that is being raised. Must address the real issue that's being raised. And as to prejudice, I don't even want to talk about that. I don't know how a party cannot be prejudiced if it has not given an opportunity. At least I'm assuming the request will be turned down. If it is not given an opportunity to finish its presentation, for whatever reason, let's assume it's the fault of that client or whatever. But if the client is not then given that opportunity, the prejudice is obvious. I don't think any court would want to be addressed as to whether is it prejudicial or not to be stopped mid-sentence when you are presenting your argument. I would doubt if the court would find that, at least objectively, as I say, assume it's everyone's fault and what have you, but objectively that is not prejudicial. It's self-evidently prejudicial.
I just need clarification regarding the agreement you had with the amicus, because the court was not appraised of that agreement at any point. And I don't think anything precluded you from raising it at the time when I was outlining the times. Nothing precluded you from raising it. I just need clarification regarding that agreement.
Okay.
Yeah.
No,
what was the agreement?
Okay. The agreement was, okay, when we got here, I don't want to make it long, yeah. We had Mr. Ngalwana and myself and Mr. Matibedi had a discussion about, I think it was 30 minutes. Yes, about the time that was allocated to
So
him.
he would have given you his 30 minutes?
No, Mr. Matibedi typically did not want to get involved. He even said, how you divide it up between myself and Mr. Ngalwana is up to us. But he would have given us the 30 minutes.
Mr. Gaulana would have given you the 30
No, no.
minutes? Mr. Who?
Mr. Matibedi,
Or Mr. Matibedi would have given you the 30 minutes?
Would have donated, quote unquote, between myself and Mr. Ngalwana his 30 minutes. That's, in short, that's what we had agreed.
I see. Okay. Thank you.
Thank you.
We're taking a short adjournment to conference over this issue.
Can I just give an indication in case, yeah, so that we don't do toing and froing? From our point of view, what we need to wrap up, should that opportunity be granted, will not be more than 15, 20 minutes tops. Thank you.
I confirm your agreement.
Thank you. Thanks.
All right. We adjourn. We will not be long, so senior counsel should not step out.
Yes.
Mr. Mpofu has expressed a complaint on behalf of his client, the first respondent, that essentially the complaint is that the argument of his legal counsel has been unfairly cut short, and that amounts to a Zuma law because other litigants are not treated in that manner. Mr. Mpofu, you may sit, yes. I would like to place it on record that the parties have filed a joint practice note. We're currently working with a third revision, so a third amendment of that practice note. In the practice note, the parties agreed to the time allocated to each for argument. In the first practice note, there was a proposal. We were given two options, and it was for the court to then determine the final allocation and the option that would be adopted. We debated. No, in fact, we didn't debate. We were quite flexible to be guided by the parties. There's a letter I addressed to the parties following a case management meeting, I think it was on Monday, essentially curtailing, revising the times that the parties have given, and that resulted in a second practice note being filed. So the times that the parties have used to argue are actually the times as agreed by them. So this morning, when I mentioned in court that we have revised the times, we did not in any manner curtail time allocated to any party. We changed the times, but the time allocated to each party was not curtailed. And in fact, the first respondent was allocated more time than was initially set out in the second amended practice note, because according to the outline there, we would have started at 10. Mr. Mpofu requested yesterday that we start at 9:30, and we accommodated that request. It's important to also mention that yesterday, the court was meant to adjourn at 4, and we went over time. Mr. Mpofu was the one on his feet at that time. We went over time. We finished between 4:20 and 4:30. Today we started early. Mr. Mpofu was meant to argue until 11. He actually argued until 11:30. So even if the indulgence, Mr. Matibedi, even if the court was aware of the indulgence that Mr. Matibedi afforded Mr. Mpofu and allowed that indulgence, Mr. Mpofu still went over time when he argued. So in the final analysis, the first respondent has been afforded almost 1 hour 30 minutes more than agreed between the parties. When one takes into account the 20 to 30 minutes that we went over time yesterday, the fact that today we started early at 9:30, which was not the initial plan as per the practice directive, and then he didn't stop at 11 when he was meant to. He continued until 11:30. So the notion that the court is unfair to his client has no basis, because this court has actually been extremely accommodating and has afforded substantially more time to Mr. Mpofu to argue than was agreed. And invariably, that gives him an unfair advantage over the other parties, because the other parties, as we've heard from the council, they have stuck to the allocated time. In fact, Mr. Manaige did not even exhaust the full 2 hours. When he was warned by the court, he ensured that he does not exceed the time allocated to him. So this court has not treated the first respondent in any unfair or prejudicial manner. In fact, as I've indicated before we adjourned for tea, Mr. Mpofu has consistently ignored. When I tried to warn him about time, I started warning him at 20 to 11 to say, are you watching the time? And I noted at that time, Mr. Mpofu, that you verbalize the words, you will deal with it at an appropriate time. I'm not sure what you meant about that. But what actually happened is that 11 a.m. came and went. And when I warned you at 11:15 to round up, you simply proceeded. By 11:30, you were still not rounding up. Now, we had a debate regarding, do we give you more time to round up, as you've asked, 10 minutes, or don't we? And this is the difficulty. This court has respected the parties and the public that is in the court, that when we have committed that we'll be here at 9:30, we were here at 9:30. When we adjourn, we are back on time. However, Mr. Mpofu has been the only person in this courtroom who essentially operates by his own, the times that are known only to him, because even when you argue and even when I warn you, I have no idea when are you going to stop. So I have no confidence that even if I were to allocate you 10 minutes, you will respect that. Be that as it may, the ruling is that the request that you are allocated more time to finalize your argument is refused. This court has a full set of your heads of argument, and it will take into account all the legal submissions that you've made in your heads of argument when it deliberates on the issues and when it renders the judgment. Thank you.
As a court, and just so that we understand, at least I can explain to my client, the times that you have computed about what was agreed, my lady, does that also exclude, is the right to reply, which was agreed by the parties, also refused?
The directive in respect to the right to reply, and Mr. Manaige has clarified that it's not correct that they've agreed that you have that right. It's actually in paragraph 6.1 of the practice note.
Yeah.
and I'll read it into record. It
No,
says,
I'm aware of it, my lady. All I'm saying is
no, Mr. Mpofu. The matter is set down for 2 days, following a virtual case management meeting on 15 May and a directive from the court on 16 May 2023. The parties agree to the following time allocation, noting that the applicant submits that the first respondent does not have a right to reply. So there isn't an agreement that you have a right to reply.
Yeah,
And the directive I've given regarding your request to reply is that you do not have it. However, in the event that in his reply, Mr. Manaiche raises new issues in relation only to the points in limine that necessitates that you deal with them, we will afford you time, and we will indicate the timeline then, bearing in mind what the issues are.
that point.
Yes.
Thank you, my lady.
And lastly, I
Yes,
need to say something about your remarks about the Zuma law.
Madam.
Yes. Those remarks are utterly inappropriate. And from the reasoning I've given from this ruling, clearly, there isn't any new law that is applied only to Mr. Zuma. And I've demonstrated in my reasoning how he has been accommodated more than the other parties in this court. And it's inappropriate for you to be accusing the court of unfairly treating Mr. Zuma.
Well, thank you. On that one, at least since you're addressing it to me, I did not do any such thing, except to, as I was at pains to point out, convey the sentiments of my client, and I will convey similarly that response to him, but it has absolutely nothing to do with me. On the issue of the right of reply, and I don't want to waste more time because now we've spent 30 minutes to save 20 minutes. So I'm saying that the right of reply in our submission is not a matter of favor by the applicant. It's a right that we have because the points in limine are raised by the applicant. And ordinarily, once the response or the answer to that from the applicant has been given, then the applicant, quote unquote, in the points in limine has a right of reply. As a matter of law, it's not a favor that we were begging from Mr. Manaiche. But secondly, and I will convey that to the client as well, because that's how I had conveyed it to him when he wanted that right. But ultimately, it boils down to one thing: it's the court's decision, and I think the court has made its decision clear. But I just wanted to explain that the issue of right of reply was not a favor we're asking from anyone. Thank you.
Mr. Ngalwana. Okay, I think the manner in which we should approach the question of whether and to what extent, if we do allow you to address the court, is that the court should first address, rather express its concerns about the manner in which you were admitted, the scope of your submissions, and why is the court concerned about the relevance of your of the submissions you intend making? Are you fine with that approach, or would you like to address the approach to address the court first? We've read your reply to Mr. Manaiche's response to your written submissions.
Well,
How would you like to approach the issue?
Justices, obviously, we would prefer to address you on all those issues. And in addition, we have additional issues
Yes.
on the merits that we would like the court to hear, because the merits of our argument dovetail with the reasons why we are here. Because if we are accused of advancing argument that is irrelevant for purposes of this court reaching its decision on the facts and the law that are raised here, it is important to show the court why the argument that we advance is relevant.
So you'd like to address the court
We would
first?
like to address the
Okay. Yeah, again, we shouldn't spend more time than you would have spent arguing on this issue, right? Because as I've indicated, the court is very concerned about the scope of your engagement.
We'll address that.
Yes.
Justices, it's now 23 minutes after 12. I take it we have 30 minutes until 12:53.
No.
I
We're
thought
dealing,
we
no,
allocated 30 minutes.
that's, Mr. Ngalwana, we first need to deal with the issue of relevance, because remember, if you make submissions in relation to issues that are not irrelevant, this court has to take them into account. So we first deal with the scope, and then you will argue within the scope as directed by the court.
We start off by saying our role as an amicus is simple but difficult at the same time. It's difficult because, well, it's simple first because we don't support either party. I just want to put that up front. We're not here to support either the first respondent or any of the respondents. But it's also difficult because we are here to assist the court if the court would like our assistance. Now, the full court has made this or has already said that it does require our assistance and made that an order of court. We present here arguments that neither party has presented or even thought of. And so, in other words, we operate in the court's blind spot, we'd like to think, because neither party has seen fit to address the issues we address, and which may give this court a different perspective on the case that it would not otherwise have considered. That is the role of an amicus. The applicant now belatedly attacks our contribution as irrelevant. We have addressed that attack in the written note that we handed up yesterday and we gave to our learned friends. So they've had more than 24 hours to consider it. And I understand that they're going to be advancing argument in that respect. But since our time allocation has been substantially curtailed from 1 hour to 30 minutes, not by agreement by the parties but by the court, we hope to use whatever time is allocated to us more fruitfully and efficiently in addressing both the relevance issue and the merits issue, which we see as intertwined. So to that end, we raise 3 points, and this will become clear as we go in our argument. But also to assist the efficient use of the time, we have prepared a short note. You'll see that our heads of argument were some 43 to 45 pages. We have narrowed it to 20 pages. And the reason for doing this is that we know that we're not going to go through all the issues that we would like to address, but our client should not be prejudiced by that fact if the court has a written argument which the court can consider. There's nothing new in it. It's just curtailing and highlighting the issues that are important as presented in the heads of argument. I beg leave to hand it up.
Hold on to your revised heads. Anything further regarding whether we should be hearing you and the extent to which we should hear you?
Yes.
Do you have anything further to say in that regard?
Plenty more.
Okay, I need to give a ruling on that issue, so I'd like to hear other counsel.
Well, there's plenty more because the 3 points that we say we want to address you on
Yes,
are related directly to the relevance of our argument.
yes.
It's in my submission, in my respectful submission, it will not be possible for the court to make a determination of whether or not what we address in the court on is relevant without hearing us on the 3 points that we would like to address you on. because it's after you heard the 3 points that you'll be able to determine whether or not those 3 points are relevant to this issue.
Okay,
Coming to the determination.
Mr. Ngalwana, all that I'm trying to say to you is that you have filed a reply to Mr. Manaiche's response to your written submissions, right? In that reply, you itemized the issues you'd like to address the court on. So the court is aware of the issues you'd like to address it on. And I'm asking you whether is there anything further that you'd need to address the court
And my answer is yes. ma'am.
on? Yes.
My answer is yes.
Okay, go on then.
But I'd like...
Yeah, but what I'm saying is that it's not necessary for you to take us through those issues because
No.
you've set them out in the reply.
Not exhaustive.
Okay, you can add on then.
Yes.
Yes.
May I hand up the note? On the
Not
additional
at this.
issues.
Not at this stage.
Not at this stage.
Not
right.
at this stage. Yes.
The 3 points we raise are, firstly, let me start off by saying we're operating on the basis, on the assumption that there is no null prosecution certificate that is valid before the court. That is the premise.
Sorry, Mr. Ngalwana. All I'm asking you at this point is that you itemize those issues. Don't repeat what's in the reply. We've read it.
I'm not going to repeat what's in the reply.
Okay.
Or at least I'll try my best not to repeat what's in the reply. The first point, let me itemize it
Yes.
first. The first point is that a private prosecution is a valuable constitutional safeguard against prosecutorial inertia or unreasonable refusal to prosecute and at the same time issue a null prosecution certificate that is required in terms of Section 7 of the CPA. Now, if the prosecuting authority that has a responsibility in terms of the CPA to issue a null prosecution certificate is biased in favor of the accused person, then that constitutional guarantee is hollow.
Okay, Mr.
That is the
Ngalwana.
first point that we
Mr.
make.
Ngalwana, I've noted those points. Those points, they are in your reply. Simply give an outline of what you intend adding.
Right.
Just
Well,
an outline. Don't argue the point. Just give an outline.
That's
Yes.
what I'm doing, with respect. And then the second point of the 3 is simply to point you, without arguing it, to the comparative study that was done in relation to the 8 countries that we referred to. The third point is the slap point. And we say in that regard that the application by Mr. Popo says by the president, but it was intended to be the person of Mr. Ramaphosa, but whoever it is, let's call him the applicant. The application by the applicant has all the hallmarks of what the Constitutional Court has called the slap.
Yes, please don't argue that
That's
point.
it.
Yes, don't argue that
Those
point.
are the issues. But, my lady,
Yes.
we wanted to give an example. We wanted to give an example of where the prosecuting authority has bias and therefore the constitutional guarantee that is provided by private prosecution rings hollow. Because it's on the understanding of that issue that your ladyship can make a determination of whether or not what we present to you is relevant.
Okay.
May I give you that one example?
No, you're not arguing at this point.
I'm not
I've
arguing,
asked-
I'm just giving
No,
an
don't
example.
give the example. Not at this point.
So you don't want to hear about
Mr. Ngalwana,
Instances
I've
like-
asked you to outline your argument, not to argue. So don't give an example at this point. Anything further?
May I just say this, my lady and justices? Without the amicus as admitted by a court order
Yes,
more than 4 weeks ago, 4 months ago,
yes.
without the amicus being allowed to set out examples of what it is talking about,
Yes.
Simply itemizing the issues are not going to be of any assistance to this court. And so we may as well never have been admitted.
No,
as
I
a-
don't think you understand me. Can I ask that you sit at this point?
Thank you.
Thank you. Mr.
Court,
Manager?
please.
Mr. Court, please, my learned friend, Ms.
Oh, yes, Ms. Mufango, yes. Okay, you are not, at this point, we only dealing with the relevance issue.
Right.
Right, yes.
My lady, I've heard the exchange between your ladyship and my learned colleague. We set out the basis of our opposition in our main in response to this on the relevance issue,
Yes,
which is our only basis for objecting, was relevance and nothing else.
yes,
So I don't wish to repeat that. What we have not done is to respond to the submissions filed yesterday with the court
yes.
that responded to our objection. I wonder if I might address the court on that.
Okay, the court needs to make a ruling on the relevance question. Right, so that's all I need you to confine yourself to at this point.
Correct.
Yes.
And that's the only basis of our objection in any event. So the submission is this, not to repeat what's in our heads, but to respond to what was filed yesterday, which goes to relevance.
Yes.
The amicus submits that Section 173 of the Constitution permits this court to entertain. Let me take a step back. The premise of the objection to relevance was that there is no challenge to Section 7 of the CPA.
Yes.
Now, in response to that, the amicus argued that Section 173 of the Constitution permits this court to entertain the submissions, the comparison that the amicus put before court. The response from the applicant is that Section 173 would permit no such thing. Section 173 permits the court to regulate its own process, and that does not entitle the court with respect to reinterpret law that is not challenged. That's the submission at this stage, which goes to relevance. Yes, court, please.
Thank you. Mr. Matimedi, you're staying out of it again?
As it pleases the court, my lady, I leave that in the hands of the court.
Thank you. Mr. Mpofu?
My lady, no, we have nothing to add except to say that the issue, at least insofar as it arises from the issue of prosecutorial bias,
Yes.
that we debated that issue yesterday.
Yes,
And therefore, there's a cross-pollination on that. And we understand Mr. Ngalona's point to be looking at that point from a Section 34 point of view.
Yes.
And we say that just on the point that is raised by my learned friend, Ms. Muvangwa, that there was this debate, in fairness, my lady, before Sutherland DJP's court, which is why he did not admit the amicus in the Part A, but only for Part B. And it was even debated as to whether if there would be a constitutional attack on Section 7,
Yes.
it can be properly raised by the amicus or should be raised by us.
Yes.
And our take on it, and that's all I'm going to say, our take on it was that it is not, to make that Section 34 point, it is not necessary for us to attack the constitutionality of Section 7, because the Hande case that everybody knows says that in interpreting Section 7, in any case, this court would have to try to find the interpretation that favors the Constitution first. You can't just come and attack constitutionality. And so that's our stance on the issue of whether there was any duty on us to attack the constitutionality. I want to make it clear, we do not attack the constitutionality of Section 7. We simply say it must be interpreted in favor of our clients' Section 34 rights to institute a private prosecution and not resort to self-help, which is the purpose of Section 7 anyway. Thank you.
Okay, thank you. Nomthandazo, where's my note? The note that I said you should file here. Where is it? Remember, there were two notes. The note, dear Mr. Ngabana, I said you should file it here. I need it. Somewhere here. Just check this file.
to say something.
No, he's got the right to reply. I'll come.
Yeah.
Yeah. I gave it to her, I said punch it and then put it here. Okay. Yes, Mr. Galwana. No, sorry, I wasn't ready to hear you, but you do have the right to reply. Relevance issue, just on the relevance issue at this point. Yes.
Right. Just on that issue, relevance, when the full court 4 months ago
Yes.
made an order admitting the amicus to advance the very argument that we have advanced in that note and in the note that I wish to hand up to the court and to argue to it, it was very much aware of what those arguments were going to be, what the basis for that argument was going to be, and most importantly, the relevance of those arguments to what this court has to determine. And so unless this court disagrees with the order of the Sutherland J Court, it would seem to us that we should be heard. Thank you.
The difficulty that this court is sitting with, Mr. Galwana, is not so much that we disagree with the order, right? The difficulty we are sitting with is whether the submissions, it's the relevance of the submissions you intend making, right? And this is our difficulty. We note that you were admitted as an amicus in terms of an order granted by the Part A full court on the 18th of January, right? We note from the papers that you probably would have wanted to be admitted in Part A, but that did not happen. You were only admitted to intervene in Part B, right? On the 18th of January, the issues between the parties were not fully defined because the parties were yet to supplement their papers, answer, reply to each other's papers in respect of the relief sought in Part B, right? So it appears that when the full court in Part A issued the order, it may not have engaged with the scope of your intervention because your application sets out elaborate submissions that you intended making in the event that you are admitted, right? And then when one looks at your written submissions, the ones filed on the 8th of May, you did not address all the issues that you set out in your application to intervene. You have curtailed the issues, right? And that buttresses my point that the full court did not consider the scope of your intervention as it ought to have done so in terms of Uniform Rule 16 Big A4. It didn't do that. It simply admitted you. And this is not a criticism to that court. I don't think it could have done that because the issues between the parties were yet to be defined. So when are the issues finally defined? The issues are finally defined only 2 weeks ago when the applicant filed its reply, right? And shortly thereafter, your own submissions are then due. So this court is sitting here with defined issues, and we're looking at your intended submissions against the issues as defined between the parties in the papers, right? So the first point you need, can I have that note in front of me? Sorry, my clerk is, I don't know where she put my notes, so she's trying to find it. And I've actually made notes on it. So in relation to, I'm gonna first deal with the comparative analysis that you did, right? So the comparative analysis that you did, you basically studied jurisdictions where a nolle prosequi certificate is not required to commence a private prosecution. But that's not an issue that's advanced.
That's not entirely correct.
By,
if I may interject.
Yeah, but the gist of your argument, the gist of your submission around the comparative analysis is that given that in other jurisdictions the certificate is not required, then here, right, to non-suit a party on the basis that the requirements of a certificate were not met will curtail his rights. That's essentially the argument you'd like to make, right? However, here, okay, you'll respond to that, Mr. Ngalwani. Bear in mind here, none of the parties are asserting that a nolle prosequi certificate should not be a requirement. None of them are asserting that. One party is saying the certificates relied upon were not valid. Another is saying the certificates are valid. Right. So the comparative analysis, having looked at your submissions, does not find relevance in the issues that stand to be determined on that point. Right. As the applicant has pointed out, the SLAP argument no longer arises because the applicant no longer persists with an order for costi bonis pauperis. So that argument no longer arises. Now, there's an issue that has arisen regarding the independence of the NPA, as Mr. Mpofu has pointed out. And that issue, I note that it's the third issue that you'd like to raise. And the court has pondered, I mean, the court would welcome your assistance on that issue. Clearly it has arisen. But when one, and this is the issue that, because if there's any window open for you to argue, it's on that point, the independence of the NPA. But I've looked at the submissions you intend making, and the point then arises, what bearing do those submissions have on the issues before court? Because essentially, what you intend saying in respect of that point is set out in paragraphs, from paragraphs 20.11 of your reply, going to 2014. And in 2014, it appears that that's really where you're taking those submissions. And you say, so the notion that the National Prosecution Authority owes no fealty to the applicant is belied by the constitutive legislation. So it's unclear to what end, how you intend to use those submissions to assist the court in relation to the issues in relating to the issues that stand to be determined in this application. And that's really where I need your assistance, yes.
Then I will address the court on that level of independence issue. But I wish to make a few corrections.
Sorry, I need to be clear. Are you considering the relevance point in relation to the first and second issue, and you are
Absolutely
agreeing
not.
to confine yourself to the last point.
I am not conceding
Okay.
anything, Justices, but if the court doesn't want to hear me on those issues,
Yes.
it is not in my province to insist on doing so.
Yes.
But I wish to clarify a few issues. The amicus's approach is not simply to say that you have other jurisdictions where the nolus prosecutis certificate is not required. We pointed to an example of a judgment of what used to be the House of Lords in England. It's a 2012 judgment of, we abbreviate it by saying it's Gutschda, where I think it's Justice no, he's not in that case. I think it's Lord Justice Moberger, who says the certificate, they don't call it is in fact a nolle prosecutis certificate, in England is rarely used. And when it is used, it's usually used in instances where the court finds that the accused is not fit to stand trial. So that is not an instance where a nolle prosecutis is not required at all. And another point that is made in that case is that a private prosecution can be stopped only after the accused has pleaded, not before. The third point is, nowhere in any of these jurisdictions does the accused have the power to stop a private prosecution. It is the function of the national prosecuting, or an equivalent of the National Prosecuting Authority, to do that, which South Africa does have in Section 13 and Section 6B of the CPA. So that's the first clarification I wish to make. So our submission is not simply to compare apples with oranges and say in South Africa a certificate is required, in other jurisdictions it is not required, therefore we have a doorway to sneak in some argument that is not relevant here. That is not what we are arguing. Secondly, regarding the slap suit issue, it's not quite accurate with respect to say that our argument is now moot because the president, or the applicant in this case, is no longer pursuing personal costs against the legal representatives of the first responder. Firstly, mootness, as I think we point out in that note, is not an absolute bar to litigation on a particular issue if it is in the interest of justice to do so. We've referred to authority of the Constitutional Court in that regard. So even if our argument were limited to the personal cost orders against the representative of the first responder, this court would still have the power to determine that issue because of its importance. There are at least 5 issues that the Constitutional Court sets out, or factors that the Constitutional Court set out as instances where the court would have to determine an issue even if it is moot. But our argument doesn't end there. It goes to the, not just the seeking of cost on a punitive scale against legal representatives. It hits the application itself because of we've referred to the judgment of the former Chief Justice, for example, in how he defines what a president is, the power that the president has, and the renown that this president has as a billionaire against an octogenarian who is retired. That is where that slap argument is anchored. The third issue, I can't read my own handwriting now. The issue in relation to the independence of the NPA is inextricably linked to the constitutional safeguard issue, which is the first issue that we we highlighted to the court. And so if I'm going to talk about the independence of the NPA, I have to talk about why we have private prosecution in the country in the first place. Because the legislature must have foreseen that there could be instances where those who are tasked with doing prosecutions may be compromised. And so the person who is the victim of the crime would have the right to bring such an application. And so with that, my lady, I would like to make an example or two of prosecutorial inertia that goes to the lack of independence, or that goes to demonstrating the lack of independence on the part of the NPA. It's not an accusation that I make. It is the facts that speak to it. One example is the Pikoli issue, which is in the founding papers of the application. When President Mbeki established a commission of inquiry to look into the fitness for office of Advocate Pikoli, the issue, at least from Advocate Pikoli's then NDPP perspective, was that he's being targeted because he's not paying fealty to politicians.
I'm going to stop you from arguing that point at this point, because we need to rule on the relevance, and then you can proceed.
My lady, with respect, you invited me to address you on the independence of the NPA, and that's what I'm doing.
No. I need to rule on the relevance, because you've indicated you're not conceding the other 2 points, so that it's clear what you're addressing the court on. So I know that you are proceeding to address the court on the NPA issue, and your scope has not been, there's no ruling on the scope of your engagement.
May I inquire, am I going to be allowed to address the court on the independence of the NPA as invited by the court?
I need to consult with my brothers, and then I'll give a ruling.
As the court pleases.
Okay, Mr. Ngalwana, the ruling is that your scope is limited to your submissions in relation to the independence of the NPA, and reasons for excluding the other 2 points will be set out in the judgment.
Thank you. It's now 12:56. How much time do I have?
It's lunchtime.
Okay, you had 30 minutes for 3 points. How much time do you need for 1 point?
15 minutes.
15 minutes you have. It's 5-2, so you'll argue until 10 past. Thank you.
Thank you, my lady. So the starting point then is we look at what exactly is the reason for introducing private prosecution in the first place. And we say that this was introduced as a valuable constitutional safeguard against inertia or partiality on the part of authority, and as a useful constitutional.
Excuse me, Mr. Nalana. You'll recall that I did not permit you to hand up your revised submission. So if you are addressing us from that submission, you may hand it up now.
Yeah, I was about to say you hadn't ruled on that issue. Thank you for reminding me.
Thank you.
So, Justices, you will have seen that the 20-page note addresses all 3 issues. So, but I will jump straight to only the issue for which we have permission to address you. And that issue starts at paragraph 6. It's only what's the word, bookmarked at paragraph 6. But the argument starts at paragraph 7. But where I want to go is a question really that was put to me in a different court, which was a valid question. That if the NPA or the DPP refuses to issue a nolle prosecution certificate, your client has a right to come to court and review that decision. So there is no need to develop the common law in that regard. And that's the point we address at paragraph 11. We say a review is not a sufficient safeguard. This talks to the independence of the National Prosecuting Authority. It is not sufficient safeguard, firstly, because prosecutorial indifference of the DPP or the National Prosecuting Authority as an institution can easily be marked by a never-ending investigation. So they could say, no, we're still investigating the matter. Now you take that to court and say, well, this investigation is unreasonable. How can you expect a court to say further investigation is unreasonable, unless, of course, it's gone on indefinitely for many years, which is exactly what happened in the Craddock 4 case. The Craddock 4 case, you will recall, was a matter in 1985, long time ago, when political activists were murdered by apartheid agents. Then there was the TRC, which ruled that those who have committed political murders should apply for amnesty. If they fail to obtain amnesty, then they must be prosecuted. Or if they have failed to even apply for amnesty, they must be prosecuted. They were not prosecuted. There has recently been an application to the NPA by the families. Since 1985, prosecutorial inertia. That is one example. There is another example, a more recent example, of what has become colloquially known in South Africa as Phala Phala Farmgate, involving the applicant. You have a decision or a recommendation of an independent panel led by no less than a Chief Justice that finds at paragraph 264 of its report that the applicant, prima facie, may have made himself guilty of a criminal offense in section 34 of PRECA. A criminal offense. And the matter goes to Parliament, and Parliament whitewashes it, so there's nothing to investigate. It goes to the police say they are investigating. What are they investigating? There is a prima facie finding by luminaries in the field of law. All that's required to start a prosecution is a prima facie basis for the charge, not reasonable doubt. The prima facie basis is there. But has the prosecuting authority taken that up to prosecute? No. Does one come to you, justices, to review the decision of the NPA not to prosecute? If one does do that, you'll be told, well, they are still investigating. There's nothing unreasonable about it. What would the victim of that crime, what choice or what option would the victim of that crime have in those instances? Prosecutorial inertia, prosecutorial indifference, prosecutorial insouciance, prosecutorial partiality. So what we're saying is the court should, using section 173 of the Constitution, be able to step in there and say, we cannot allow the very prosecuting authority that seems to have an interest in not seeing the accused person prosecuted be the one who has to issue the so-called certificate nolle prosequi. The court should have that power to itself, as in Canada, itself issue a summons and say there is a prima facie case for prosecution here. It wouldn't be overreach. It would be judicial use of the powers at its disposal in the form of Section 173 of the Constitution. That's all we're saying. Well, on this point.
Thank you, Mr. Ngalana.
I'm sorry, my lady, I was just saying, that's all I'm saying on this point. I just wanted to say.
Recall, you have one point, so this point is the one point, isn't it? Is there any other point?
Yes, we still have 7 minutes, but I don't have to use up the 7 minutes.
Yes, you don't have to. We need to hear other counsel.
Yes, because I was given until 10 past, so I'm just conferring with my
That's
learned
fine.
friends.
Proceed.
So, Justices, in closing,
Yes.
the amicus's submission is private prosecution is allowed in the statute because there is an understanding that the National Prosecuting Authority may not be the perfect body to give permission for a private prosecution to happen because of various reasons, including indifference. I'm not going to go to corruption. I don't want to be seen to be accusing the NPA of being corrupt. Please let that be understood. The amicus is not saying that. The amicus is saying private prosecution is a safeguard against a possibility of the NPA being indifferent to bringing a state prosecution against certain individuals, whether it's because they are powerful politicians or businessmen, and that the court should be able to step in there without requiring them to go on review. I mentioned only one example of or reason why a review would not be a viable one. I've listed, I'm not going to read them out, I've listed them in paragraph 11. Yes. Paragraph 11, there's a long list there that justices may consider in their own time, so I'm not going to bore you with those. Thank you, Justices, unless there are further questions.
Thank you, Mr. Ngalana. Mr. Manaicha.
Just on the amicus. I can do our reply, and in that time I will deal with the main reply and my learned friend, Ms.
Perhaps I should hear
the others
first,
the court, please.
just on this, and then you can reply on all the points. Mr. Matibedi.
As it pleases the court. My lady, until such a time that the Criminal Procedure Act is amended, the NPA and the various heads of the provinces are the appropriate bodies to issue the certificate. And we respectfully submit that the examples that were mentioned relating to the CREDOC 4, TRC, and others has no bearing in this case to demonstrate that the second and third respondents did not carry out their duties as expected in terms of the Constitution. That is our submission. We submit that there is no merit in this case to attack the conduct of the second and third respondent. That's our argument.
Yes, but doesn't this create difficulty where you have to, in fact, determine whether you're going to prosecute one of your own? I can't have a family member of mine appearing before me. I have to recuse myself. Here there's a person who is from a high-ranking person from your office who they sought a private prosecution against, and they need your permission.
But the permission, that's how the law operates up to this stage.
Don't you think that is the point they make?
But until such a time that the relevant section is amended, there's nothing that the second and third respondent can do. And that in itself, carrying out one's a statutory obligation does not mean that one is not carrying out his or her duties in terms of the Constitution.
But doesn't that create a perception of bias? You're carrying out your duties, but it seems as if from the outset, it seems as if the process is tainted.
For the mere fact that the second and third respondent are carrying out their duties, that is not sufficient, that is not enough to create a perception of biasness. There should be more than that.
Well, then the other argument raised yesterday by counsel for the first respondent. You then give a nollie prosecution against the person. And then some members, prominent people from the DPP's office go and make press statements, almost giving testimonials of this person. I mean, in any other, apart from the NPA, such conduct will not be accepted in the corporate world. It won't be accepted in many other places because you taint it. Now you give a certificate, okay, go and prosecute so and so. They do that, but then you come out and you become his defender.
It will all depend on whether that was done intentionally or not.
Well, I don't know. But the crux of the matter is it was done. Why didn't you just stay out of it? It is an issue between the private prosecutor and the individual. Now you go and make public statements to the world at large, almost exonerating him, which a court should do.
But my submission is that it's not unusual for the NPA to give a press statement. It's unfortunate in the circumstances. And lastly, sorry.
Yes, Mr. Matveri, you had
Yes,
something more to
the
say.
last point that I would like to make is that the press statement was not made by the decision maker.
Yes. Mr. Matveri, these allegations are quite serious, as I've pointed out yesterday. And in the event that we find that any member of the NPA has violated either the NPA Act or the Constitution, we will be calling upon them to make representations regarding why we should not refer their conduct to the LPC for further investigation.
As it pleases the court, I'll convey the message to my clients.
Yes. Mr. Mbob?
Yes, thank you, my lady and my lords. I'll be brief. Let me start just quickly with the point that your ladyship just raised with Mr. Matibedi, which we appreciate. If, and obviously it's a question of if, as the court says. I simply want to point out this, that, and this really lays bare the problem with this case. If, and it's a big if, this court finds that there was such alleged misconduct, and if, as Mr. Matibedi says, that misconduct goes even beyond KZN but to the head office, then Section 12(6) of the NPA Act must kick in. And the person to execute Section 12(6) of the NPA is the president. That's what happened to all these people, Jiba, Simelane, Bigoli, and so on. And therefore, that the inquiry, which is really what this case is all about, that was the inquiry we were requiring from the president to say, there is this which is happening under the watch of the NPA. Please do an investigation on an inquiry. We thank him for sending it to Mr. Lamola, but that's not all. He has a duty under Section 12(6), where he should institute an inquiry. And if it is found that the NDPP is implicated in all of these things, she must be fired. That's how serious the matter is. I just want to flag that.
Yes.
I'm not going to develop it. The second point, my lady.
Before you move, I just want to raise something with you
ma'am.
as to whether the president would be the appropriate person to make that decision.
Is the only person.
Wait.
Sorry.
Given that he's a party here, where this complaint arises, where these allegations are made.
Yes. Well, then we will have Mr. Ngalwana talk about constitutional inertia. We would then have a constitutional crisis, because according to Section 12(6), the only person who can make that decision is the president. And so it's, you rub my back, I rub your back, and so
All
on.
I'm asking you to assist the court, if we are with you,
Yes.
that we
I
refer it to, we refer
Yes.
it for an investigation for an inquiry in terms of
12(6), for
12(6).
example. Yes.
To whom, given that the president is a party here?
Absolutely. Okay. I won't even answer that question because I'll take it as a rhetorical question. But it dovetails with the issue raised by Justice Ismail, to which Mr. Matibedi raised the issue of intention. Bias has got nothing to do with intention. Bias is what Justice Ismail was saying. If one of his members is sitting in court as an accused person, he will recuse himself. He himself might subjectively be objective and even be more objective than any judge in this country. But he cannot sit in that case because there is a reasonable perception of bias. It's as simple, it's got absolutely nothing to do with the intention of anybody or the identity of anyone. So that's the other issue. The last issue is that we want to raise is that Section 13, what we have here is actually amending the law. The law says an Attorney General, read DPP, or a local public prosecutor acting on the instructions of the Attorney General may, in respect of any private prosecution, apply by motion to the court before which the private prosecution is pending. That's another jurisdiction point. So they have to apply in the criminal court. The court before which the private prosecution is pending, to stop all further proceedings in the case in order that a prosecution for the offense in question may be instituted as the case may be or continued at the instance of the state, and the court shall make such an order. You might as well take this section and throw it in the dustbin on these facts. Because to expect, as Justice Ismail has correctly pointed out, a prosecuting authority that has issued statements, issued lawyers, paid for the defense of an accused person to invoke Section 13 ever is madness. It will never happen. So that simply means that what the legislature contemplated in a situation like this where there's prosecutorial bias, and I know that it's still alleged, as Mr. Ngalwana said, even if it's at the level of, we had this debate yesterday about whether the contents of the statement is true or false, whatever. And the point made by Mr. Ngalwana in his statement was that he doesn't want to enter that fray. And that point is similar to the point I made. I said, okay, let's assume I'm wrong. Let's assume I'm reading too much into the statement. But the very fact of an NPA that issues a statement, wouldn't life be so nice if the other accused persons who are not presidents of this country would be arraigned, and then the following day the NPA would issue a statement saying, no, this one is a holy person. It would be great. But the only reason that it is done, in our respectful submission, is twofold. One, because it's one of their own, but two, because the accused is the boss, the person who employs the NTPP, and the person in whose power it is to fire her.
Yeah, I don't think the net should be cast too wide, because the statements here, the statements that are complained of here were not issued by the NDPP. So we shouldn't be casting the net too wide.
My lady, I'm sorry. Yes, I take that point. I really do. But please consider that point in the context of our complaint as the applicant. Remember, if you read, I don't want to go through, Mr. My Nature went through it. If you go through to the 12-page letter that we wrote to the president of this country, which is part of the indictment, that is a serious matter. That 12-page letter goes in chapter and verse about officials and all the officials it says all the officials who are holders of public office who are part of this. Remember, for Mr. Downer to have leaked, quote unquote, allegedly, the certificate, he would have had to get the permission of the NTPP. So whether or not that permission was given or not given, we don't know. That will be debated at the trial. The NTPP is one of the witnesses. And by the way, one of the witnesses, to come back to Justice Ismail's point, is Advocate Zuma on the list of witnesses. So all these people are mired into the facts of this particular case so irreversibly and inextricably that to expect them to follow the prescripts as we all know them in a normal case it's gilding the lily, and it is making a mockery of the entire scheme of private prosecutions, which after all, my lady, and this is my last point, is remember that by the time you go for a private prosecution, already the NDPP the NPA has taken a decision that there's no prima facie case. So already you are starting from a negative, and they are allowed to do that. So already these are people who have looked at the case for better or for worse and decided that there's no case here. The Section 34 right of the private prosecutor is irrespective of the fact that skilled prosecutors would have made a decision that there's no prima facie case. Our law has seen it fit to provide an avenue for a private prosecutor still to prosecute that which the best prosecutors in the world have said there's no prima facie case. So already you are starting from a negative. How can you deny a private prosecutor that residual right which our constitutional writers saw it fit for them to express their Section 34 rights, even when the prosecutor bona fide, forget about all these things about bias now, even when they bona fide believe that there is no case here.
Thank you, Mr.
Can I ask you this, Mr. Mofo? I haven't thought this thing through, but you've raised it in response to what I've said. You know, these proceedings are televised. And let me presumptuously assume, I don't believe it is happening, but the applicant is watching these proceedings because he's got a stake in it. He now sees, well, there are things that was raised in this court I should have taken into account. And he then yields to your client's submission initially. This afternoon, he decides, I'm going to hold a commission of inquiry against the NPA. Now you'll say, well, it's late, but rather late than never. He's now realized this ex post facto that I've given it to the minister, nothing was done, but there are valid grounds here, raised by you, raised by Advocate Galwana, and raised by everybody, which he didn't have the benefit at that stage. He now changes his mind. Would it render this proceedings moot?
The short answer is no. And it is for this reason. Well, let me tell you in practice what I would do if that happened this afternoon. This evening, I would go to my client and I would say to him, you have, your wish has been realized of getting to the bottom of how your medical information was bandied about. Now, you have two options. You may want to withdraw the private prosecution if you think that vindicates if you think that vindicates your rights equivalent to a conviction. I'm just saying. You may withdraw the private prosecution. But the reason why the answer is no, Justice Ismail, is because the irrespective of what the president can do now, the crime has been completed. The crime, remember, is a very simple one. By omission, when you have a legal duty to act, whether it is in terms of Section 12.6 or Section 84 of the Constitution, you have, that's the actus reus, you have omitted to vindicate my rights intentionally, for whatever reason, but intentionally and unlawfully. And therefore, you fall into the definition of accessoriness or the definition of, what is it called? Obstructing the ends of justice. Now, that may be a question of sentence.
Yes, in other words, it's mitigating.
Absolutely, yes. When the sentence comes, the court, then they can say, well, just like we were saying with the security. We say, okay, we didn't comply with the security, but ultimately the security is paid. So the court might say, but Mr. Prosecutor, should we really go for the 15 years maximum sentence when, or they might even say it's de minimis now, because let's assume he did it a week after. As you say, he thought, oh, well, I made this decision, but I was wrong. I think when it's 2 years, it's a bit much. But let's say it was a week. The court might say it's de minimis and really everyone's rights have been vindicated. In any event, if the person is innocent, they will be vindicated. But the bottom line is that in pure criminal law, the answer is no. But in the practicalities of life, it might be yes, because the private prosecutor might say, we all know that if a complainant withdraws the charge, it doesn't mean the state is compelled to do so. Thank you. Those are our submissions.
Thank you.
I'm sorry. I promise this will be half a sentence. After all this is said and done, from our point of view as the first respondent, it boils down to one thing and one thing only, and that is this question of interpretation. Because when all these things are considered, this court, for example, as it was threatening to do yesterday, yield in its interpretation of the certificates, yield to the views of these people who have done the things, assume for now all the accusations we make hold some water? Yes or no? If the answer is no, then the interpretation, the more reason why an interpretation that is objective and based on the documents should be favored. And on that interpretation, I've already made the submissions on that interpretation. If the person is an accessor after the fact, anywhere in the world, they can never say, and that goes to the interpretation of the words in connection with.
Mr. You've gone back to your case.
No.
Yes, please conclude. Please conclude.
I am concluding, yes. My lady. Okay, that's fine. Looks like I'll never be able to finish any sentence in this court. Let me just round off that thought then, my lady. I'm saying that we must not be waylaid into all these issues. Of course, the court has an interest as a court of law as to prosecutorial independence and so on. Yes, but from our narrow, selfish point of view, as the first respondent, although we have raised and flagged those issues, we are saying ultimately the court should take this. It's the so-called surrounding circumstances argument of interpretation favored in the Endumeni case. As the court please.
Thank you. I'm not against you.
I know, my lady. This is a very difficult case, but all I want is for your leadership to appreciate. I hope the court knows the duty of counsel. That
no, I
so I don't want.
In fact, I've been less robust with you than I was with Mr. Manainji, but the response is not the same. So anyway, we're here now,
yes.
right? We're almost at the end.
But my lady, let's rather not have this discussion, because I will then point out that Mr. Manager, the reason why he complied with the time is because there was less robust engagement from the bench. But I don't want to, but I'm not saying that. As they say in the township, I'm not saying anything. but that's...
Okay, who's coming next? Is it you, Mr. Okay, it's 1:30. So what do we do? I'm keen to just continue, and then we end. We continue right to the end. Are you happy to continue right to the end?
There's a comfort break request, and then we can...
Then we can continue.
Can this person do even me?
Are you asking for a 5-minute adjournment?
That's correct.
Okay, we'll just adjourn for 5 minutes. Mr. Mpofu, you want to start directing the court? Sorry, Mr. Ngalwana would like to say something. Mr. Ngalwana? Yes.
Are you really excused if you want to be?
You've got the right to reply.
We have a right to reply.
Yes.
Thank you.
We adjourn for 5 minutes. Thank you.
Just by way of general remarks, it's important to recall what this case is about. I am not here to defend the NPA. I'm here to advance the case for my client that there is a deeper principle at play, which is a defense of the rule of law. And it is not a case about Advocate Dana SC. The Dana SC's private prosecution is in KZN. In that respect, the NPA has issued a nolle prosequi. He has taken the issue up in KZN court. The judiciary, the court, will determine what the merits of that complaint is. So when we talk about the NPA and independence and impartiality and what it is serving this country, we must recall that under the Constitution, all organs of state have an obligation to protect both the NPA and other organs of state. In the Dana case, as we understand, and from these facts, a nolle prosequi certificate has been issued, and the judiciary, which is tasked with the function of defending the Constitution, will determine that issue ultimately. If there are issues of independence that arise in that case, that court is seized with those issues. This court is not seized with those issues. So to the extent that they are raised in relation to my client's case, they are peripheral issues. They make and they serve only to cloud issues in this case.
The issue raised here relates to the media statements.
Yes.
That's how it comes.
Quite, and that
issue
relates to my client.
The issue of prosecutorial independence.
Yes,
it
but
comes in that context. It's not in the wide context.
Correct.
And that's how I understand.
What I'm submitting to the court is that ultimately this court will not decide my client's case based on that media statement. This court decides cases based on the law and the facts that are presented to the court. In motion proceedings, affidavits contain both the legal issues and the evidence. It is to the affidavits that you're going to have regard to, and not whether Mr. de Kock acted out of 10 and whether that has any implication to the way in which the DPP herself discharged their function. It is only in that context that I raise the point. That there might be an issue to report about the NPA and the conduct of officials of the NPA is on the side. The real issue that we are in court about is whether this private prosecution is lawful and valid. And for that, the evidence from the NPA is the affidavit of the DPP and not a press statement. Because a press statement is hearsay evidence because Mr. de Kock has not presented an affidavit before this court. And he is the author of that press statement. As to what he meant by the president or Mr. Ramaphosa is not referred to in statements, he's not here. He hasn't explained it. We are all guessing as to what he means and what he doesn't mean. But it doesn't decide the matter which is before the court. This court must look at the affidavits, must look at the legal contentions that are raised in the affidavits and determine the matter, not by reference to hearsay evidence. So I say my client's case is a very humble case. It is not about the constitutionality or the suitability of our scheme of public prosecution and private prosecution. It is accepting that that scheme exists as all the parties accept, and to determine whether Mr. Zuma has brought himself within that scheme in order to prosecute my client. If he hasn't, our submission is there is ample authority that this court has jurisdiction to put a stop to that, and I'll come to those authorities. The second point I want to deal with is just the question of security. My learned friend might have misunderstood. I did not say I don't recall the case management meeting. Of course I recall it. And I recall the court proceedings. What the court did on that day, it reminded us that we were in urgent court. We don't have the luxury of a whole day of debate, and that there were certain issues that it did not believe would be determinative of the matter, and it disposed of them. For instance, the fact that the affidavit was not properly commissioned of my client, the fact that there was an issue about security. What the court said is that, this is our recollection, this is an issue that could be condoned. We didn't understand the court to be giving an order condoning. And there's a simple reason for that. At that point, Mr. Zuma had not yet paid the security. He hadn't even paid it by the time we had the case management meeting. So it is unlikely, and I say this simply, it is unlikely. I'm not suggesting that my learned friend's recollection is not better. All I'm suggesting is, from our understanding, it is unlikely that the court in the case management meeting, which was not a full court, constituted full court hearing, did in fact condone the security issue. I can
Manager, you will recall that I directed
Yes.
that the attorneys for the first respondent should simply approach the DJP, who I believe was the presider, right, in that matter.
Correct.
For that order, so that we don't rely on any party's say so regarding how that court dealt with this issue.
Yes.
If the court condoned failure to pay security at that point,
Yes.
then there should be a court order.
Yes.
Simple as that.
All I want to do in that regard is to give the court a reference in the affidavits which reflects how my client understood the issue and how we conveyed the issue to my client. And that is at page 1348 of the replying affidavit, and you will find that at paragraph 122 to 123. What we say, what the client says in that paragraph 122 is that I admit that the Honorable DJP has expressed that the payment of the security could be condoned. I reiterate that whether this may be condoned after the summons have been issued and in what circumstances is a legal question still to be determined by this court. In light of the fact that the first respondent keeps vacillating between saying that security has been paid on the one hand, and that's in the affidavits, the answering affidavits, the previous in Part A, and saying that it will be paid, further shows that why this court has to decide whether Section 9 may be read to mean that payment of security may be condoned at all or on the facts and circumstances that apply in this case. Bearing in mind the infringement of rights that come with a criminal prosecution, whether private or public, it is important that a determination be made on whether security may be condoned and in what circumstances. That's where I leave the matter. But we don't abandon it, as I confirmed yesterday before this court. Then may I turn to the question of standing. We submit in relation to standing that our learned friends kick a lot of dust, and lawyers are skillful in kicking up a lot of dust. He says to the court, when he reads the founding affidavit, he says, you have a juristic person before you. That's the submission.
Fictitious.
But I beg your pardon. Same thing. I beg your pardon. A juristic person is a legal fiction that makes it a person and gives it rights. It's not flesh and blood like us. What he's saying is you don't have flesh and blood before you. Let me put it in simple language. He says you have a fictitious person, you don't have flesh and blood. And he says, how do you determine that? You look at the heading. It says President of the Republic of South Africa. That's a fictitious person. That's an office, if I can put it in more simpler language. And then, of course, he has to read. He knows that you can't read the heading and ignore the affidavit. In the same way that you don't read the notice of motion apart from the affidavit to understand what relief is sought and what the case is that is made for the relief. So he's forced to go to the affidavit where he reads, I'm an adult male and the President of the Republic of South Africa. So you have a human being, but he's a president. Of course you have flesh and blood. Who says I'm cited in a private prosecution and my rights have been infringed? It's a human being telling you all of those things, which for purposes of standing, and I took you to giant concepts, you have to accept, because you deal with standing almost as if you're dealing with an exception. So you accept that the facts that have been alleged can be proved. And on the basis of those facts, you determine, there's an old judgment which says, in fact, that locus standi is determined on the basis, almost on the same basis, an exception. I just don't have the reference. So, but that's the basis on which you determine it. In fact, giant concept says you accept that the merits are proved. You accept that there is a breach of constitutional rights in our case, and that the prosecution, the private prosecution, has been unlawfully instituted. Now, in those circumstances, and I don't want to go back to giant concepts, it tells you how you determine standing, where breach of rights are concerned, how broad the concept of standing is under our constitution, where you have a person, you have a human being. Even if, and I submitted to the court that even if all you had was an office, that office has an interest in that the incumbent is prosecuted through a lawful prosecution, because the president, the office, has a constitutional obligation to defend the Constitution. And the Constitution, by defending the Constitution, you are defending the rule of law, which is the underlying value and the principle. So there is nothing to this standing point. It is raised because the first respondent, with respect, has to raise all these in limine points, because when we get to the merits, the true merits, there isn't a case. There's no answer to the case, and I'll come to that. So we say you should dismiss that standing point. The next point is the question of jurisdiction. Now, the starting point is that Section 1061H of the Criminal Procedure Act doesn't pretend to be, and it is not, a jurisdictional provision. It is a provision about pleading when a person is in the criminal court. That person may be properly brought to the criminal court by the public prosecutor, where there's no issue about title, or there is an issue about title, which will be raised, or it may be in a private prosecution, which is based on a proper nolle prosequi certificate and summons that are validly issued, and you can plead under 1061H. It is not a jurisdictional provision. The question that what you ask on this jurisdiction point is the first respondent correct to say that if a private prosecutor institutes a private prosecution which does not comply with Sections 7 and 9, which is alleged to be instituted for an ulterior purpose, which constitutes an abuse of court process, and where the alleged offense does not even constitute a criminal offense, that Section 1061H says that person, that accused, with all of those complaints, can only complain in the criminal court and by raising 1061H. That is the, if you find against my client on that basis, that 1061H is exhaustive on all of those complaints, must only be raised under 1061H in the criminal court, come what may, then we will fail. But we submit that the authorities are against that proposition, including the authorities that my learned friend read to this court this morning, the NETCO judgment, for instance, which is repeated. So the first judgment is Solomon, the 1950 judgment. And may I say, I don't have any private jokes with my learned friend about Solomon. It is good law.
That's what he said. He has with his
he has. I beg the court's pardon. What we want to refer to in Solomon is at page 334. You remember 027334 in the bundle I handed up yesterday. My learned friend Mr. Mpofu read one part of it, and I just want, let me just make sure that I'm reading it right. Yes. So at page 334, towards the foot of the page, maybe about 6 paragraphs from the foot of the page, you'll see that there's a summary about what the application is about. It says the present application is based upon 3 main grounds: that the respondent has no interest, such as in Section 14, that the prosecution is inspired by personal malice and is unfounded and vexatious in the sense that it has no hope of success, that the respondent elected to carry out the terms of the award. That relates to the arbitration award that was particularly complained about. Then it says just below that at the outset of the hearing, Mr. Atif for the respondent took the point in limine that this court has no jurisdiction to entertain the application. He considered that for the purpose of argument upon this point, it must be assumed that the factual grounds upon which the application is made were true. In other words, that the respondent had no substantial and peculiar interest in the issue of the case, and that the proposed prosecution was unfounded and vexatious and inspired by the indirect motives referred to in the petition. In support of his contentions, Mr. Retief referred to the provisions of Act 31 of 1917, that's the predecessor to Section 7 under the CPA, which regulate the conduct of private prosecutions, and in particular to the following sections. First, Section 17, which obliges the Attorney General, if he declines to prosecute at the public instance, to grant the aggrieved private party a certificate to that effect, and which then entitles the private party to obtain the process of the court for summoning the accused. Section 18, which refers to the right to take proceedings which is conferred upon the private prosecutor by the Act. And Section 18b, which requires the private prosecutor to find security for the cost of the accused. Section 20, which provides that the private prosecution shall be subject to the provisions of the Act and be proceeded with in the same manner as if it were being conducted at the public instance. Section 23.2, which authorizes the court to award costs to the accused where the prosecution is found to be unfounded. Section 1751G, which entitles the accused in a private prosecution to plead that the prosecutor has no title to prosecute, 1061H, and so to raise the issue that he has no such interest in the course of the trial as is required by Section 14. He maintained that under these provisions, the grounds upon which this application was based were left to the determination of the court in which the prosecution was laid, the criminal court, and failed to be decided in that court after the hearing of evidence. The provisions referred to were intended to be exhaustive, that's the argument was made, and excluded the jurisdiction of the civil court to intervene. I was unable to agree to this view, that's what the court says. It says, and accordingly overruled the preliminary objection for these reasons. I can find in the sections relied upon no evidence that the provisions relating to the cost of unfounded and vexatious prosecutions or the title of prosecutor to bring the proceedings were intended by the legislature to be exhaustive and to exclude any right to invoke the assistance of the Supreme Court, as the applicant now does. Mr. Retief maintained, I think, in support of his contention that the provisions referred to were exhaustive, that under sections 17 and 18 of the Act, the private party who had obtained the Attorney General's certificate was given an absolute right to prosecute, of which he could not be deprived by the court. No doubt the sections referred to do bestow a right to prosecute, subject to the necessary conditions. You recall about paragraph 54 of Nundalal yesterday says, yes, you have a right to prosecute, but subject to the conditions of section 7 and 9. But I cannot take the view that that fact excludes the jurisdiction of the court to interfere on proper causes. If Mr. Retief's contention were correct, this court would have no power to intervene, even though it were shown in the clearest possible manner that the party who had instituted the private prosecution had no interest whatever in the outcome of the trial and had embarked upon it for some ulterior motive, such as, for example, to prevent a business competitor from leaving the country on his lawful business or to delay him in so doing. In such a case, if the prosecution were launched in the Superior Court, I do not consider that could be held that the remedies provided in the sections of the Act to which Mr. Retief referred were exhausted. The taking out of the summons would clearly be an abuse of the process of the court, in that it had been undertaken not with the object of having justice done to a wrongdoer, but in order to enable the prosecutor to harass the accused or fraudulently to defeat his rights. The process of the court provided for a particular purpose would be used not for that purpose, but for the achievement of a totally different object, namely for the oppression of an adversary. The court has an inherent power to prevent abuse of its process by frivolous or vexatious proceedings, and refers to a number of cases. Although this power is usually asserted in connection with civil proceedings, it exists, in my view, equally where the process abused is that provided for in the conduct of a private prosecution. In such a case, as I have postulated, therefore, this court would, in my opinion, by virtue of its inherent power, be entitled to set aside a criminal summons issued by its own officials or to interdict further proceedings upon it. It is also by virtue of its inherent power that the court interferes to restrain illegalities in inferior courts, either by way of interdict or mandamus or by declaratory order, as it on occasion has done. So Solomon is a clear authority that you can approach the High Court. And the next case is the case we cited, Van Deventer. That's the case of prosecuting a judge because the private prosecutor doesn't accept the judgment the judge rendered. And the page that I want to refer the court to is 027-5, so it's page 5. And the relevant points here, just to get, yes, it's on that page, sorry, my file is catching. On that page, you will see a discussion under no prospects of success, vexatious, and an abuse of process. And the court say the crime of defeating or obstructing the course of justice consists of the unlawful and intentional commission of any act which defeats or obstructs the administration of justice. As you heard, even my learned friend reminded that of that. And then the court went on to say, after this, the second line after that line, says, I think that it is abundantly clear that the first respondent has no prospect whatsoever of establishing that the applicant committed the offense of defeating the ends of justice. And that's the first point. And then under locus standi, you'll see that the court deals with the standing under section 171A of the Criminal Procedure Act of the private prosecutor, and says section 71A of the Criminal Procedure Act entitles a private person to institute a private prosecution where the Attorney General declines to prosecute in circumstances where that person proves, and then it repeats the requirements. And below that it says the underlying purpose of confining private prosecutions to those who have a substantial and peculiar interest was expressed as follows in Van der Heever, and refers to that. And then it refers to the Solomon's judgment, you'll see before that, with approval. And then concludes that I therefore hold that the first respondent does not have locus standi in judicial to institute the private prosecution against the applicant because it doesn't meet the requirements of section 7. And what is the relief that is given is that the private prosecution is interdicted at paragraph 3 of the relief, which you will find at page 0276. And that is that the court exercises jurisdiction despite the fact that part of the complaint goes to title of the private prosecutor and also goes to abuse of process. So both of them are dealt with in that case, and the court interdicts the private prosecution. It doesn't say your only remedy is to go to the criminal court. The next judgment is the NETCO judgment, which you have been referred to by our learned friends a couple of times, and they've read to you paragraph 26. They read paragraph 25 and then read paragraph 26. But I want to read you 25 to 27 because you've got to see it in that context. That the court says for title, you can raise that, as my learned friend reminded me, says you should raise that in the criminal court. But for abuse, it determines the matter and in fact grants an interdict. So even if our learned friends are correct for some on the argument that you should go to the criminal court for title, but we complain about abuse of process, ulterior purpose, all of that, the court has jurisdiction to grant relief. And even in NETCO, that's in the NETCO judgment, which is at page 027-12, you'll see under paragraph 25, the heading is the issues and the law. It says 25, the applicants contend that the institution of the private prosecution is irregular, vexatious, and an abuse of the process of the court in that inter alia, 4.1, the first respondent lacks the requisite locus standi to proceed. 2, the summons comments in the proceedings is invalid for want of compliance with section 10. And 3, there is no prospect on the first respondent's own version of events of any court convicting the applicants. 4, the institution of the private prosecution is actuated by mala fides on the part of the first respondent. And 5, the prosecution was initiated with an ulterior motive to oppress and harass the applicants rather than to secure criminal justice. You'll find those allegations in the founding affidavit about harassing, oppressing, ulterior purpose. Then the court says at 26, the points taken in subparagraphs 4.1, 4.2, and 4.3 relate to the merits of the prosecution. But that's really title. It must be clearly stated, however, at the outset that this court does not have the power to usurp the functions of the magistrate. For example, the challenge to the prosecutor's title should properly be raised in the magistrate court by way of a plea in terms of section 1061H. The issue before me, he goes on, is whether the proceedings in that court are vexatious, amounting to an abuse of the court process, and if so, whether the circumstances constitutes proper and sufficient grounds in law and on the facts for the granting of the relief prayed for by the applicants. The contentions raised in regard to defects in the prosecutor's case are relevant to the extent that they impact on that issue. And then over the page at 27, it says, ordinarily, the reasons and motives of a party for instituting legal proceedings are irrelevant. However, when the court finds an attempt made to use for ulterior purposes machinery devised for the better administration of justice, the duty of the court is to prevent such abuse. But it is a power which has to be exercised with great caution and only in the clear cases. The learned judge made the comment in the context of misuse of a rule of the court by one of the litigants. But in Solomon, Roper J. found the dictum to be applicable also to private prosecutions. In Van Deventer, the court held that it has the power to interdict a private prosecution which is irregular, vexatious, or an abuse of the process of the court. The power derives from the inherent jurisdiction of our superior courts to prevent abuse of their process. Although such power will be exercised with caution and only in the clear case, the courts will not hesitate to act where necessary, lest the administration of justice attract disrepute. The power shall be exercised in the light of all the relevant facts and circumstances and with due regard to the intention of the legislature as reflected in the statutory provisions, if any, pertaining to the particular proceedings. And what did the court do? Said an abuse of court process and granted an interdict. Said the first respondent be and is hereby interdicted and restrained from proceeding with the prosecution in the Magistrates Court, Port Elizabeth, instituted by him under that case number. So those three cases are the clearest authority that we don't have to go to the criminal court and participate in an egregious breach of our client's constitutional rights, which is an abuse of this process of this court. This court has the obligation to protect its own process against disrepute of that kind. And my client comes precisely for that. And for purposes of jurisdiction, this court has to accept that my client has pleaded that case, and that case is that case on the pleadings that determines whether this court has jurisdiction. Now we hear that, well, there's a prematurity point, because even if we may be right about it, just because we can go under 1061H, the Supreme Court of Appeal and the Constitutional Court in Tint, Moyo and Tint, have said, don't countenance such preliminary litigation. One must pause a little bit and try to understand why the courts are concerned about preliminary litigation. They are concerned about preliminary litigation whose purpose is clearly to delay the conduct of criminal proceedings. That much Justice Langer, acting Chief Justice at the time, said in that paragraph that we quoted so many times, both of us, yesterday. So one asks oneself, is the case before you one that is aimed purely at delaying criminal proceedings? And so if you think of it in that way, the concern is not limited to using civil courts. It is also a concern that extends to using criminal courts, where you use what has now come to be known as the Stalingrad tactic, where preliminary litigation is embarked upon one after another for decades to avoid a trial ever commencing. That is what the justices are decrying. Whether it is in the criminal court or is in the civil court, and it's a famous person or not a famous person, that is contrary to our need for a proper administration of justice, and that's why they decry it. But they are quick to say, but we are not closing the door. We are not setting an absolute rule, because there will be deserving cases where the interests of justice cry out for intervention. And Justice Presiding quite rightly said, Moyo was such a case, because ultimately The constitutional challenge raised in the SCA, which the SCA complained about, ultimately was upheld by the Constitutional Court as a genuine constitutional challenge and reminds us that we mustn't stretch the language of legislation under Section 39(2). This echoes what reminds me of what our learned friend behind us for the amicus was presenting. His whole argument is use 173 to find something else about Section 7. But Moyo reminds you that courts are bound to be faithful to the language of legislation. You're only entitled under 39(2) to give a meaning which you court considers to be constitutional if the language of that statute is capable of such a meaning, reasonably capable of such a meaning. If it is not capable, you strike it out as unconstitutional, which is what Moyo did in the Constitutional Court, as opposed to what the SCA tried to do. So ultimately, as the Justice Presiding said, in Moyo and the Constitutional Court, the finding on the constitutional issue became dispositive. It saved the accused persons from being dragged through an unconstitutional criminal prosecution. In that case, it was warranted. The interests of justice warranted it. Our learned friends say, well, because the courts say generally you don't allow it, that means there is an exception. And the moment you talk of exception, then the test is exceptional circumstances. The court said, show us where is a single judgment of the SCA, the Constitutional Court, a provincial division, which says the general rule is don't go to the civil court to raise a genuine constitutional challenge in a private prosecution case. If you do, you must show exceptional circumstances why that rule must be departed from. To this day, we are waiting for that judgment to be identified. All we are told is you must read generally to mean that the corollary is exceptional. But we know that our legislature, when it means that you must show exceptional circumstances, says so. Section 18 of the Superior Courts Act is one example in point. Interim relief orders are not automatically suspended by a lodgement of an application for leave to appeal unless you can show exceptional circumstances where they should be. On the other end, if it's a final order, you lodge leave to appeal, it is stayed automatically unless you can show exceptional circumstances why it shouldn't be. And the courts have defined for us what exceptional circumstances are. Now, we are told that just because our learned friends, both Mr. Mwela and my learned friend Mr. Mpofu, say so, they submit. When you ask, the court asks, where is it? I submit so. I submit that it is an exceptional circumstance test. But where is it that's not how courts decide matters. You have to show the court, this is the law, these are the facts. On the analysis of the facts and the law, this is the outcome you must adopt. And we submit this kind of making assertions in court is unhelpful to the courts because that's not how decisions must be taken by courts. And we submit that there's simply no basis in any of the cases that have been advanced that there is an absolute rule and to be departed from only in exceptional circumstances. There is a flexible rule which tends on the interest of justice. This case is not about a mere delay. It's not at all about mere delay. You've heard from my learned friend himself telling you that there is personal animosity animating some of these complaints here. When we complain about an ulterior purpose, and then coupled with that, we show you that the president was never a suspect, you can see that clearly the clearest case of illegality is presented to you. The court is duty-bound to intervene. And I move in that way to the merits. Because you were told that you must not concern yourself with what the DPP tells you, you must not look at intention, you must look at indumeni, the modern approach. And there's a judgment of the Constitutional Court in the Electoral Commission versus the Minister of Cooperative Governance and Traditional Affairs. You will recall is the case when the IEC wanted to have the elections postponed, the local government elections postponed because of COVID. There was a subsequent judgment which was about the interpretation of that order, part of that order, whether political parties were given the opportunity again to register or not. And Justice Rogers, writing for the court, uses this words modern approach to interpretation. And that is the approach which says you look at words, you look at context, and you try to give effect to the purpose of the provision. And my learned friend urged the court, you must give effect to the purpose of Section 7. Now, what is the purpose of Section 7 in circumstances of criminal private prosecution? It's very clear from the section itself. It says, the DPP is presented with a charge in a sworn statement which was presented to the police, a charge against a person. The DPP must confirm in a certificate that she has applied herself to the affidavit, the charge as set out in the affidavits, in other words, supported by the evidence in the affidavit, and has declined to prosecute the charge. Not, I've declined to prosecute, because you can only prosecute a charge. And on the other hand, there must be a person. You can't prosecute a charge in a vacuum. My learned friend gave a very good example in this accessory after the fact, because he, as he says, he's been a lecturer before. He likes to say that, unfortunately, I wasn't in his class, but he said he thought I was. But yeah, this is obvious, that's why I'm here. But the point is simple. He says, assume there are 5 people in a cell and there is a body, and you don't know who killed that person, and then you're going to look for either the primary perpetrators or accessories. We just happen to have a similar case going on, but we take his as a manufactured one. Now he says he gave 2 years, 10 years, 15 years down the line. It turns out that somebody who was not thought to have been in that room either was or helped in disposing the body or something like that. He's an accessory after the fact. We don't quibble with that. But the president wasn't in that room. The president wasn't in that room in the first instance. And in the second instance, they tell you when the president started committing what they allege to be an offense. Because they say, we sent a request on the 19th of August, and he responded on the 25th or 26th of August. So his actus reus, because although his crime is connected to the primary crime, there is an act of his own which he's blamed for, which is intentional and unlawful. That act of the president only manifested after the request. It could never have manifested on the 9th of August. Now, there are very many supporting contextual indications why that is the correct way to understand this. It is that the sworn statement of the former president itself names the president as somebody who's doing something good for justice. He is investigating the complaint against Mr. Downer, him, the minister, and the LPC. The judge is also mentioned, but he's mentioned because he's sitting in the court, also advancing the cause of justice. Now, by a stroke of magic, if that is proper English, you are meant to now understand those people who are mentioned for the positive deeds they're doing for justice to also have been mentioned as suspects. I only need to state the proposition to show how ridiculous it is. Because even the judge then is a suspect. The Minister of Justice is a suspect. The LPC is a suspect. Maybe the summons are coming. But it is really to stretch incredulity to the greatest extent. This is not a suspect. If one was doubtful of that, then you have the supplementary affidavit of the former president himself in the court in KZN, where he describes the events. And I read this affidavit to the court yesterday, and that is at page 933, 015-254. And it's paragraph 16, 17, and 18. In his words, not in the words of his counsel trying to play with words and context and purpose and try to confuse all of us. No, in the words, the clearest words under legal advice of the former president. He says this at 16. The alleged misconduct perpetrated by Mr. Downer and the MPA in leaking the medical letter was reported to the president in a complaint filed with him and copied to the NDPP and the Minister of Justice. He attaches the copy. 17, I must point out that at the time of its leaking, the only person who was in possession of a physical copy of the report or letter was our lead counsel. He is the one who blew the whistle and informed the legal team and Mr. Zuma of what had occurred in the discharge of his professional obligations. As such, he will give assistance to any investigation if called upon to do so. 18. In response to Mr. Zuma's resultant complaint, the current President of the Republic has since informed us that he had directed that a full investigation be conducted on the NPA's conduct. We are awaiting from the Minister the opportunity to make an input in that process and have been instructed to place before him some of the evidence involving Mr. Downer and the NPA, which is already before this court, so as to demonstrate that the most recent conduct is part and parcel of long-standing behavior on his part and that of the NPA. A copy of the letter from His Excellency, President Ramaphosa, is annexed here too. Not the accused is annexed here too. Because here he's lauded, they are waiting for the minister, his executive, to contact them so they can give assistance. He is advancing the cause of justice. How is he ever to be understood in the contemporaneous documents at the time by the DPP to be a suspect in an act which involves an accessory after the fact for the disclosure of the medical reports, or an unlawful act of defeating the ends of justice? Recall that although a lot of noise is said about this, is not trivial. It is about confidential medical reports. Who would want their medical reports disclosed? The allegation against the president is not that he disclosed anybody's medical reports. And that president says in his letter he regards this allegation in the very serious light. I read the letter to the court. So, with the greatest of respect, there is simply in this world where we read documents, we read the law, and we have to interpret them taking into account the ways that were used at the time, the context in which things were happening, and the purpose of the documents and the provision that the president was ever a suspect for a charge. And that is really where the meat in the section just collapses. My learned friend, in answer, we said, the things change on the eve of Nasrec. On the 15th of December, a summons is issued. The 16th of December, Nasrec commences. And what happens at Nasrec? The issue is raised that you are arraigned in a criminal prosecution. You can't stand. These are all, or if I stepped out the mark, I think the date of the 16th is correct. Perhaps it's, what happened at the conference you can strike out. I don't think, I wasn't there, and perhaps it's not in the affidavits. Thank God. But the point is this. So we say there's a sudden change, and I think the DPP's affidavit has a word for it, either a stroke of luck or something like that. They have better use of language about game rangers and all this. We don't have, but poachers and rangers. But they debate that with my learned friend. I think they have a better understanding of this. But the point we're making is he then says, no. Actually, there's an answer in the correspondence that was engaged in, which will show you that my client always wanted to prosecute. And therefore, this sudden change is not true. But with great respect, that correspondence does not help our learned friends at all. The correspondence is discussed in the paragraphs that are mentioned to the court, a common cause between the parties. That's paragraphs 13 to 19 of our heads of argument, and they are confirmed to be common cause at paragraph 19 of Mr. Zuma's heads of argument. It just happens that we all are around paragraph 19, but this shows the extent of the commonality there. The correspondence is addressed in more detail in those paragraphs, and my lady and my lords will see from paragraph 13 that a discussion of the correspondence begins. And we include a copious quotation from correspondence at paragraph 16, which concludes in the following way. It says at paragraph 7, and you'll find that at page 1707. Given all these objective facts and the blatant irrationality of your decision, they're attacking the DPP, it is incumbent upon you to assist in avoiding unnecessary and protracted litigation on this matter by forthwith reversing the aforesaid decision, making a decision whether or not to prosecute Ms. Mon, issuing the requisite amended or separate nolle prosecution certificate by the deadline set out below. In any event, you have had sufficient time to make a decision one way or the other as to whether Ms. Mon must be prosecuted on the basis of the allegations made against her by the complainant in his affidavit and her own affidavit, which form part of the docket. The suggestion that you require a full investigation to be conducted over and above the past investigations is plainly irrational. Beyond any dispute, those correspondence were about trying to expand the knowledge or make it clear that it's not limited to Mr. Downer. It includes Ms. Mon. We don't argue for Ms. Mon. She argues for herself in KZN. We carry on that. That correspondence nowhere says Mr. Ramaphosa is a suspect or faces a charge, and we want you to issue a nolle in respect of the president. What they really did was to clutch, to grab an opportunity that was presented by a nolle which says it's issued against any person, even though it then narrows that down by giving you the charge, the date of the crime, and telling you that is in connection with that matter. They grabbed on that and said, well, this allows us to issue summons against Mr. Ramaphosa. So we received this nolle on the 21st of November, 2022. We can now do something about Mr. Ramaphosa, and we issue those summons on the 15th of December to prosecute him for alleged criminal offense. We submit with great respect that there is nothing in this that support the proposition that Mr. Ramaphosa was ever a suspect and the nolle was in respect of him. So we submit with respect that the common cause facts make it very clear that this nolle was not about a charge. He says, on inference says, we are fixated with the nolle is not about Mr. Ramaphosa. No, we are not only fixated with that. We're saying it is not about a charge against Mr. Ramaphosa, an offense against, because that's the language of the section. So we submit that that's the end of their case. We should get the interdict and we should get the review. But it goes further than that, is because the prosecution is frivolous and vexatious. The conduct of the president here, which he told them and they're charging him for, is that he referred their complaint to Minister of Justice and Correctional Services and the LPC for an investigation. And they say, well, that's a criminal offense. We submit, for a criminal offense, it must be unlawful and intentional, as my learned friend said. Where is the unlawfulness when the president acts consistently with the Constitution? He acts lawfully. Section 85(2) of the Constitution says the president exercises executive authority with his cabinet. 91(2) says he assigns functions and roles to his cabinet ministers, and he's assigned the function of supervisory function over the NPA to the Minister of Justice and Correctional Services, and he assigns this investigation to him. That is perfectly lawful. It's not a crime in South Africa, with great respect, under our Constitution. You can never convict Mr. Ramaphosa for referring this complaint to the Minister of Justice and Correctional Services and the LPC for investigation. At best, you could get a court order to force him to make sure the minister does his job, whatever, a mandamus. You will recall that a Mr. Terry Crawford Brown made a demand to the former president for him to establish a commission of inquiry into the arms deal. He didn't take the former president to prison or to the criminal court for refusing, not instituting, refusing to establish a commission of inquiry, he went to the Constitutional Court. And I was junior counsel with Advocate Marumo Moarani, SC of the KZN Bar, to defend that decision of the president. But ultimately, the former president then agreed to establish a commission of inquiry. You can't prosecute a president for saying you've demanded a commission of inquiry in the exercise of my constitutional powers under Section 85, I'm not instituting a commission of inquiry. You can go to court and challenge that decision as unconstitutional and obtain a mandamus. So we submit that given the absence of a nollie so clear, the security so clear, this is not a criminal offense so clear, this is a classic abuse of court process over which this court has a power and role and duty to stop a disrepute on the administration of justice by granting the orders we seek, including the final interdict. Those are our submissions in reply, my lady and my lords.
Thank you.
As the court pleases.
So you've limited your reply to the amicus in respect of the general remarks you
yes.
made? Is that where you
the general remarks and the fact that 173 doesn't give you license to interpret
Yes, you said
statutory
it.
provisions the way you want.
I'm just
as the court pleases.
wanting to make sure that you've addressed.
Yes, I conferred with my learned friend and she said that's all.
That's it.
As the court
Great,
pleases.
thank you. We'll hear Mr. Olwana first.
You'll be happy to
Do you-
learn,
do you-
Justices.
pardon?
We've said everything we need
Yeah,
to
I
say.
thought so. Thank you. I thought you wouldn't need to reply, given what was said in response to your. Yes.
We have said everything we need to say as allowed by the court.
I sense a complaint then. Well, you'll also be happy that I'm going to be, I'll only confine myself to the new points. The first one is, well, in fact, if I make this point, that might be the only point I'll ever make. Mr. Maineche says, and I'm quoting him verbatim, when he's criticizing my example, although his crime, talking about his client, although his crime is connected to the principal crime, he was not in the room in that example, as it were. Well, I should then just sit down. Because once we are at least agreed that his crime is connected to the principal crime, then that's the end of the case. Because all we've been arguing for the last 2 days is exactly that. That the nolle prosequi doesn't attach to a person. It attaches to any person who is allegedly, at least at this stage, connected to the crime. As we explained with Justice, at least confirmed with Justice Ismail yesterday, the two principal golden requirements for accessoriness is there must be a principal offender and there must be a principal crime. All the NTPP said was, or rather the TPP said was, all those people, and the TPP has no obligation to give them names and say, here's their name and ID numbers. It says any person who is connected to this particular crime this thing applies to them. Full stop. So if Mr. Manager didn't raise the other points, as I say, I would say at least thank God we are on the same page as to whether the nolle applies to. So the nolle stands there. It's up to all of us. If I say Mr. Mwela is covered by the nolle, he will then say, no, but I was not there. I was not even mentioned in the affidavits, and so on and so on. So this exaggeration is of saying, then it means the judge, then it means this one. No. All those people will have, nobody says that judge has intentionally, one, and unlawfully participated in the crime. But here, and this is the biggest problem which is committed by Sutherland DJP at 14.8 of his judgment as well. The actus reus can never be a crime. Because he says, can it be a crime to omit to do something, and then he says it's a radical idea. No.
Okay, I'm going to remind you that the terms of your right to
Reply.
reply,
Yes.
it's in relation to the points in limine.
Yes.
New
but-
points.
Okay.
New issues,
Yeah,
point in limine.
that's
You are
fine.
dealing with the merits.
That-
You don't have a right.
All
to
right.
reply.
Which is well, if there's a concession that has come, at least I should point it out to the court that the crime is connected, well, even if it was unwitting or inadvertent. That's fine. That there's a connection. Fine, my lady. You're right. On the points in limine, there are 2 points that Mr. Manecha has raised, which are new. One is this idea that the Solomon's case and the Nedco case and so on are in his favor. Even just on the point in limine, let's forget about the thing about title to prosecute for a minute. But he just read out here in front of all of us from Solomon a section that says, of course, which I've considered even yesterday, of course it would be ridiculous for me to stand here and say, in a case such as the one postulated in Solomon, where the only purpose of a private prosecution is to harass somebody else, the court's hands must just be tied to say, oh, well, sorry, you must go to section 106. That's not what we're arguing. We are saying, of course, and that's what was said in Zuma versus DPP, that's what was said in Redel. Redel actually is the only case that I know, contrary to what I was saying to Justice Bakwa yesterday, where I say courts usually, I'm sorry, I'm looking for our heads, our Part A heads. Okay, anyway, I'll just refer the court. The court can go to our Part A heads, where we've quoted, it's a 2 or 3 sentence quotation from Redel. It's one of those, paragraph 68 of that case. It's one of those few cases where the courts use the word never and doesn't even qualify it. Because it says, in the case of a prosecution, if ulterior motive is the only ground, the court will never entertain it. Never. It uses that, sorry. So just 1 second. Just oh, okay. Thank you. That's thank you, Melanie Gines. Actually, found a shortcut. Instead of looking for it in my head, just go to the case itself. Paragraph 68 says, like Zuma, this is what the Constitutional Court said. Like Zuma, referring to the Zuma versus DPP. Like Zuma, the other cases relied upon by the applicants must be distinguished from the present one. And here's the bill. As stated, the unlawful arrest and malicious prosecution cases rest on a different substratum. Bad motive in and of itself can never be an adequate ground for escaping arrest and prosecution. Bad motive in and of itself, standing alone, can never be an adequate ground for escaping arrest or prosecution. So it was expressed in such strong terms. The next point is the issue of vexatiousness. And again, my learned friend is quite correct. For the purposes of, we've shown on the merits why this can never be vexatious. But for the purposes of a point in limine, we have to assume that there are allegation to that extent, or rather for the purpose of jurisdiction, that allegation is good on the merit. He's right about that. That's how you approach points in limine. But that very point falls foul of the exact same thing we have been raising about section 1061H. So my learned friend is not allowed, or well, maybe he's allowed, But he cannot get away with, if he thinks that the Section 106 point is difficult or unanswerable, now shift the goalpost by saying, well, remember, it's also vexatious. Because he falls into the very same trap. Section 16 of the Criminal Procedure Act provides specifically, just like Section 106(1)H, Section 16 of the Criminal Procedure Act provides specifically, Section 16(2) in particular. Sorry. Says, where the court, firstly, that I can just stop there. The court that is spoken about here is the criminal court, obviously. So already they're out. But be that as it may. Where the court is of the opinion that a private prosecution was unfounded and vexatious, which is what they are accusing and which we must assume for now, it shall award to the accused at his request such costs and expenses incurred in connection with, yes, that our expression again, in connection with the prosecution, as it may deem fit. Now, even a first-year law student will tell you that that issue of the cost order can only arise at the end of the trial, 1. 2, in the criminal court. So it's obvious. So there's no place to run. Even if they run away from the Section 106(1)H argument and get into the so-called vexatious and shift the argument in reply to the allegations of vexatious and unfoundedness, which we must assume are good. The same prematurity and jurisdiction points confront them because the CPA, which is the constitutionally ordained statute, provides for that. The last point that he raised, which is new, is oh yes, and here, my lady, I don't want to fight with you because this is in relation to, if you want to rule that it's not a point in limine, but it's a point on the merits, then I will abide by that. But I thought the idea of combining these things was the recognition that the points, so-called points in limine, are intertwined. So let me just make this one point. If and this really, this is
just laughing. He's not objecting. He's just laughing because the notion that the points in limine are intertwined with the merits is arising for the first time. It's arising for the first time. I'm going to allow you to make that point. Okay. It should be a brief point.
Yeah, it will be.
Right.
Yes. Well, okay. I don't want to debate this. I'm saying that Mr. Maineche said in a meeting with you, my lady, which was chaired by you, that the reason why they were opposed to our suggestion that the points in limine must be debated separately is because they are intertwined with the merits, and you upheld that, and you made a decision that we should argue them together. And so it's in their draft joint minute. But anyway, I don't want to go there. The point I want to make is the following, that there's no Chinese wall between the points in limine per se and the jurisdiction. The point you made to me yesterday, my lady, that in Mukhesi we have to go beyond the preliminary litigation and check what were the issues there. But as I say, let me just make the point briefly. It is this, because it's a big point. I said it yesterday. The fundamental problem that everyone who doesn't understand that the crime in this matter is the breach of Section 41(6) as an accessory after the fact, not a crime called accessory after the fact, because there is no such crime. That crime, quote unquote, is an inherently connected crime, because you can be in accessory after A, B, C, D crime. And for that proposition, if you don't believe me, you must go to Section 257 of the CPA. That section makes it very clear. It's under a section called competent verdicts. Why is it there in the scheme of the Criminal Procedure Act? It is there because there's no such crime in the air called accessory after the fact. It says, smaller. I'm sorry, I'll be brief, my lady.
It's similar to housebreaking.
Absolutely.
Housebreaking is not a crime.
Yes.
It has to be housebreaking with the intent to commit robbery, theft, etc.
Absolutely. And culp, and maybe let's make, without going there, I'll make a popular example. The reason why Oscar Pistorius could be convicted for culpable homicide without having ever been charged of such a thing, and it was explained by Justice Leach in the SCA. Justice Leach said in the SCA, and I've got the passage, but I don't have time, that we accept that Mr. Pistorius was never charged with murder, or rather with culp, but he was charged with murder. But in terms of Section 258 of the Criminal Procedure Act, culp is a competent verdict, and therefore the judge was justified to so that point is out, and then they found on other points. And the simple point I'm making here is the same, the point that Justice is making, which is that Section 257, which is a twin brother or sister of Section 258, I'm sorry, says, and I'll decode it for this case. If the evidence in criminal proceedings does not prove the commission of the offense charged, put in bracket the Downer offense, but and the principal Section 41(6) and whatever, but proves that the accused is guilty or as an accessory after that offense. Sorry. As an accessory after that offense, in other words, that second offense, or any other offense. Now, read here the, what do you call it, defeating the ends of justice.
I thought you were making a brief point.
I have to make it fully. It's still brief, but I can't stop it halfway. Yeah. So, of which he may be convicted of the offense charged, and we know what the offense charged is. Then it says, the accused may be found guilty as an accessory after that offense, or as the case may be, such other offense, and shall, in the absence of any punishment expressly provided by the law, be liable to punishment at the discretion of the court, provided that such punishment shall not exceed the punishment which may be imposed in respect of the offense with reference to which the accused is convicted as an accessory. In simple English, what that means is that the person must be, in this case, if Mr. Ramaphosa is charged with the offense of accessoriness in terms of 41(6) and the alternative, he may be found guilty of that offense, combined offense as it were, provided that he may not be sentenced to any sentence higher than the 15 years. In other words, for obvious reasons, he's not a principal offender. The likelihood is that the court is not going to treat him as an offender. That's all. That's our law. This is Section 257, and it answers fully the point made by Mr. Maineche regarding his criticism of my example. And I'm grateful to the court. I know that as I said, it straddles both the merits, and I'm grateful for the court for allowing me to make it. But it's a crucial point in the understanding of the substantive law that is underlying this, because there's no ways you can just interpret the nolle prosequi and the charges and all those things and the indictment without understanding the underlying general principles of law. Let's cut this. And therefore, for those reasons, my lady, I have not made submissions about costs, and that's because in a case of this nature, I think there have been very serious discussions about criticizing both the issue of the NPA, which we've dealt with, as well as the delaying tactics of the president. So I don't have to readdress that. All I can say is that if the court finds in our favor, it must, with the greatest respect, take into account on any ground. It must take into account that by definition, this type of litigation is, and Mr. Manecha is quite wrong about that, it's about delay. I've said this, there's no other sensible reason why any person would deviate from the constitutionally ordained approaches which would remove his matter quickly and go into all these roundabout ways. And therefore, to discourage other people from engaging in preliminary litigation, however deep their pockets are, or our pockets are, if they are using the taxpayers' money, the court has to at least show sufficient opprobrium to this kind of conduct. Otherwise, we're going to be back here when it's someone else who's complaining about being raped by a minister or whatever, who's going to say, oh, well, I did it in my office, therefore I must use the state attorney, you know. So it has to be, and I'm making that graphic example deliberately, it has to be shown that the offices that people hold are not there to shield them against their own actions, even if those actions were committed literally inside the office that we're talking about.
Thank you. We've come to the end of the proceedings. We are grateful to counsel for their assistance. Judgment is reserved. You will be notified through one of the clerks to the judges when judgment is ready to be handed down. Before I forget, Mr. Ngaulwana, your two submissions, if you could please load them on case lines. Thank you. Thank you. We adjourn.